Item number 1.
May it please your lordship. Well, this is a PIL filed against the apathy and the inaction of the authorities. Well, the brief facts were that there were massive corruption in the water resources department, and we filed a complaint in the year 2020, which is at page 29. We basically bring a case of violation of the rules. Tender persons were allotted tender, were given allotment without being enlisted under the rules, and also they clubbed 5 tenders into one and they gave it. Because this is a state largest, there has to be a distribution. Now, what happened when we complained it, we came to know that an inquiry was started and disciplinary action were being commenced. In fact, we could get documents which your lordship will come. Yes, this is it, page. Yes, lordship will come at page 44. This is a letter of the Commissioner Vigilance to the Secretary, WRD, Departmental Action on Inquiry Report, Vigilance, enclosed here with a copy of such and such on complaint lodged by the petitioner Lego against Sri Gagong Parting, Executive Engineer Yingkong, and other officials pertaining to various works. As per finding of the inquiry report, Vigilance, there were violations of laid down guidelines such as the APPDE Act 15 in selecting the firms SS Enterprise and OG Traders. In this regard, I have directed to convey the approval of the competent authority to take departmental action on the inquiry report as per the relevant CCR rules and other provisions of rules, which action taken report to the department. So they took it up seriously. Then we find that at the second page, at page 20, this is another letter from the Vigilance to the Superintendent of Police. So there is some movement with reference to your proposal on registration of regular case for investigation into the complaint dated 9/3/20, lodged by one such Megang Ligong, president. He's a district president, Mandal president, alleging Mr. Partin was violating the such act by awarding more than 2 works at a time to a single firm. I am directed to inform you that the competent authorities had accorded approval for the preliminary inquiry into complaint. Your file is returned herewith for further necessary action. Then we find that the government was sitting over the matter, and then we immediately file RTI. And when we file RTI, initially we were not given the documents. And after a while, when we went to the appellate authority, we were given a report, which is the relevant part is at page 49. This is the inquiry report. We come to know. Can I read, lordship?
47. At
40.
page 47.
Yes, 47. The relevant portion is at page 49. The finding. Hence, your lordship has got it. On completion of my inquiry, it is found that in the said tender, firms should have been participated, but CIL civil firms were participated, and moreover, the winning firm, MS Enterprise, was not registered one. This is very important. This is in violation of the rules. And its partner, OJ Traders, OJ Traders belongs to Sri Litim Lego, immediate brother-in-law of Sri Partin, the engineer, which is against the guidelines. In view of the above facts and circumstances of the inquiry, it is submitted with a recommendation to register a regular case against all the board members, including Sri Partin, Sri Kanon Partin, Sri Bagra, and Fila, who were involved in the whole tender process and favoring the contractors who were not at all eligible to participate in the said tender, being such, and to the contractors, proprietors of SS Enterprise and OG Traders, and such act of the board members and the proprietors of firms are amounting to cheating, conspiracy, and nepotism. The officials who are involved in the execution of the schemes had no role in the tender process and awarding of the works. Now, what had happened from that time, 21, the inquiry report was further endorsed by the chief engineer, which is at page 50. This is important, lordship. This is a letter from the chief engineer who authenticate superintendent engineer to the deputy secretary vigilance. It is with reference to the above letter in such and such. In this regard, the following paragraph comment is furnished. As per clause 4 of the 4.2a of the Arunachal Pradesh district-based entrepreneurs and professional incentive development and promotion rules 2015, the participant firm must be duly registered under Arunachal Pradesh contractors and enlistment rules of 2008 in the appropriate cases of category, and that the registration must be valid on the date of participation of the tender, a copy of which must be submitted to the tendering authority. Next is no comment. 3, this is important. As per clause 4.2.5 of the Arunachal Pradesh district-based entrepreneurs and professional incentive development and promotional rules 15, in the event of inadequate response to a tender, invited a block assembly constituency level, the eligible contractors of adjacent block assembly constituency within the district shall be eligible to participate in the subsequent call of the tender. However, there is no such provision for clubbing together of the works under Arunachal Pradesh district-based such and such rules of 15. So basically, the inquiry report was authenticated by the superintendent engineer, and from that time of 21 till today, my lord, there has been no action. So I pray at this stage, at least, a notice may be issued, because probity in public life is one of the facets of PIL.
Because steps are already been taken, isn't it? So you're saying 7 and 8,
No, 1 to 8.
1 to 8. 9 is contractor.
We have made them apart.
On the basis of the report, it my university will be only the case of this.
Yes, yes. So your main grievance is that in spite of the report which you have just read,
Yes, Lordship.
now there's no further action
There has
taken.
been inaction and apathy.
Okay, then we have just discussed the matter. And even if we issue notice, at this stage, we can issue notice to the respondents from number 1 to 8.
Yes,
Isn't
Lordship.
it?
Yes.
Now, 9 to 10 will be subject to the reply
Yes.
given by the respondents number 1 to 8.
Yes, Lordship.
Because if they are actually taking steps which you
Yes,
are
yes.
not aware of,
Yes, yes.
then the PIL itself can be
Absolutely.
closed
Absolutely.
because steps have been taken
Yes,
against
yes.
the report.
Yes,
isn't
because
it?
we are on the inaction part, and Supreme Court says that a High Court is the best forum for in these matters of PIL. There are judgments to the effect.
Okay.
Yes, madam.
Yes, heard Mr.
D.K. Das.
D.K. Das, learned counsel. Is it William?
No.
Learned counsel for the petition, who has filed the instant public interest litigation in order to expose the misuse of public funds meant for development of works in the Water Resource Department under the Kyung Division, and siphoning of funds by some officers and contractors. Okay, while awarding 5 numbers of contract works under the SIDF scheme, which is in complete violation of the, now what is the full form? APDBEP Act and Rules 2015. What is the full form? Arunachal Pradesh?
Just a minute, Lordship.
Uh,
It's a very,
yes, so let's have the full form.
yes, Arunachal Pradesh district base. It is at page 50, Lordship.
50.
Okay,
Arunachal Pradesh district-based entrepreneur and professional incentive.
yes,
development and
based
promotion.
on the Arunachal Pradesh district-based entrepreneurs and professionals within brackets, incentives, comma, development and promotional, close bracket, rules, comma, 2015. Okay, then slash AD, APDBEP Act and Rules 2015. The learned counsel for the petitioner submits that the extent of siphoning of the funds were to the extent, to an extent that even the EE of PWD awarded contract the whole 5 works to a private contractor, which was not listed with the government as required under the
Rules.
APDBEP rules, 2015, and clubbed all the 5 works into one work, which was not allowed under the said rules. The petitioner had filed a complaint before the SIC within brackets vigilance on 09/03/2020, and the SIC conducted an inquiry and the inquiry report was submitted on 04/01/2021. Good stop. Okay. Thereafter, the officer of Chief Engineer PWD on 21/10/2021 affirmed the findings of the inquiry, whereby establishing the illegalities committed. There was an order to proceed departmentary proceedings against the officials, but even after a lapse of 4 years, there are no regular vigilance case registered to book the persons who committed the illegalities and embezzling of the funds. The instant writ petition is against the inaction of the respondents, in spite of there being enough evidence and in spite of the inquiry report showing that there is some irregularities in the same matter. Having heard the submission made by the learned counsel for the petitioner, we find it fit to issue notice to respondents number 1 to 8 at this stage. And thereafter, if required, notice may be issued to the respondents number 9 and 10, depending on the response of respondents number 1 to 8. That, yes, issue notice, Mr. So-and-so, learned additional AG accepts notice on the behalf of the respondents number 1 to 8. Requisite copies of the PIL is to be duly furnished to the learned additional AG. List after 3 weeks.
3 weeks, ma'am.
Can we have a date, Lordship, since we are outside?
Okay, on, give me a date, 3 weeks.
Yes, Lordship. Can it be on 18th of November?
Okay, on 18/11/2020.
No, Lordship, one thing I would like to, since your Lordship has issued notice, a status report by the government will be required, so that may be recorded.
They
No,
respond to
it's-
the
Madam,
IA and accordingly.
Inquiry report is, inquiry is already complete. Preliminary inquiry is already complete.
Once they
That will
receive
amount
a
to
copy,
superseding
they'll respond to it.
17A, madam.
Okay, then as per their response, we'll
Yes,
see how the
we'll
case will
proceed.
progress. No?
Yes.
Oblige, oblige.
Obliged.
Yes. Counter affidavit to be filed
Sip,
by the
item
state
num
respondents.
item number 2, Lordship.
Uh,
Here, Lordship, the bias of section rule 15 of the Arunachal Pradesh Police Service Rules 1989 is under challenge, Lordship. If Lordship see the order dated 29/1/2024, Lordship.
24?
24/1 2024 lawsuit.
In which
29. Item number 2 lawsuit.
item 4?
Item 2.
The one which we're looking at. isn't it?
Order dated 29/1/2024.
2024.
Yes. 29/1/2024.
Yes. what
The
is
petitioners are from the lawsuit, they are from the Pither lawsuit. They comes under the promotional lawsuit category lawsuit. They have challenged the rule 15 lawsuit, which is mean poll lawsuit, direct recruitment lawsuit. By this order lawsuit, I have been given lawsuit opportunity to lawsuit take instruction from the authority whether it's applicable to the promotional post or not lawsuit. So instruction has come lawsuit. This is not applicable to the promotional post lawsuit, whereas they are from the promotional post lawsuit.
So,
So according to you, if that be so, nothing survives. in
Nothing
this
survives
report.
in
So
this.
file an affidavit to that effect.
I can place it. It
No,
can
no.
be on record.
you have to file a counter because it's a WPC.
Lawsuit.
No, you
Yes.
specifically say that this is the proposition and this is the clarification.
Yeah,
Because
Lawsuit.
sometimes somebody may come and say, who has instructed you to make a submission?
Yes.
That should be on record.
Yes, it has to be in form of. an
Only
affidavit.
since the written instruction is there lawsuit.
You-
So
You file an affidavit by the competent authority.
loss, no issue.
Item number 3, man.
Huh?
I mean, item number 3 only, I'm not in there.
So item number 3 also counter has to be filed.
But item number 3, everything is, petitions are complete.
Complete.
Readings are
Last of
complete.
the London Senior Council, I am representing respondent number 5 to 8.
Ah.
Since there is no grievance against respondent 5 to 8. Of course, we start writing a-
Be here for some time, we'll take up.
See, when you say get instructions, after you getting instructions.
Lawsuit, I'll
the
place on records by
instructions
affidavit.
placed
Because
in
see,
form
that
of an
instruction will
affidavit.
make this writ petition infructuous.
Infraction.
So therefore, meaning thereby, they cannot have any grievance because their grievance is that it is applicable to them also. You are saying, no, this is not applicable.
Not
to them.
applicable.
That let be on record on that basis. we'll close it.
So therefore, since it's by order lawsuit, so already written instruction has come, it can be kept on record lawsuit and
Instructions
indeed you.
by way of an affidavit.
Lawsuit.
That is not
Lawsuit.
fair in this.
Lawsuit.
That may create
Lawsuit.
multiple litigation.
I'll
Experience.
Mr. So and so appears on behalf of the petitioner while Mr. So and so learned government advocate, is it? Has prayed for further time to file his counter affidavit in terms of the instructions that has been received by him.
Lawsuit.
Accordingly, list these matters after, when you be ready, 2 weeks?
After 2 weeks.
After 2 weeks. Two, three, and- Yes. 57 days delay.
Yes.
Are you going to object? No objection?
Madam.
Are you going to file a written objection for 57 days
No, madam.
delay? No, isn't it?
No,
So, in para what, which paras have we explained the delay of 57 days?
Lordship, starts from para 3, Your Lordship.
Okay,
Three to-
now, yesterday, we had allowed a condonation of delay of, I think, very less days also. Okay, so we will pass a similar order. Okay, that not objected by the learned counsels for the respondents. Okay, and therefore allowed.
Yes.
Now, in the main repeat. There's an order yesterday for condonation, same order, only the names. Yes, what is the appeal about? Against the judgment of,
It's challenging the impugned judgment dated 25/06/2024. Pass in,
this matter, notice has already been issued
yes, Your Lordship. Notice has already been issued.
and the respondents represented. Notice was issued on 24/09/2024. Okay,
Notice
this
is
is
in
in the IA,
yes, your lordship.
but
This
it
is
has
the
been
IA.
enclosed in the
Enclosed, yeah.
appeal. Okay, fine. On the disposal of IA 177/2022. Notice be issued to the respondents. Yes, then Mr. Accept notice.
My lord, I am for the respondent number 5, my lord.
Okay, Mr. M.
Amended.
Kato, learned BS GI accepts notice on behalf of respondent number 5,
5, my lord.
while Mr.
The come to
Deep
for
Babu
respondent number 1 and 2, my lord.
accepts notice on behalf of respondent number 1 and 2.
Yes.
And
I'm
Miss-
respondent number 3 and 4.
okay, Miss the learned government advocate accepts notice on behalf of respondents number 3 and 4. Requisite copies of the appeal to be duly furnished to the learned counsel for the respondents. Any private respondent? No.
No problem,
Let's after 3 weeks.
my lord.
Deep offer.
Oh, okay.
May I please, Lordship? Lordship, I beg to mention item number 21, Lordship. Consent has been taken from respondent side, Lordship. This matter may be fixed on 29, Lordship.
29.
Yes, Lordship. Next Monday, Lordship. Tuesday, Lordship.
We'll fix it the week after. The hearing matters when the court is going to sit on it. This bench will not be sitting for a long time.
Yes, Lordship.
Mention is made. Is your name here in the cause list?
Yes, Lordship.
Your name?
H. Titara, Lordship.
Okay, your name is not in the cause list, isn't it? So you're appearing on behalf of?
N. Duncan, Lordship.
Okay. Mention is made on behalf of Mrs. N. Tangan, learned counsel for the petitioner for adjournment of the matter, which is not objected by the learned counsel for the respondents.
Yes, ma'am.
In view of the above, this is matter on, not this Monday, the Monday after?
Tuesday, Lordship.
Okay, Tuesday. Not this Tuesday, the Tuesday after. What's the date? No, not this Tuesday, the Tuesday after. You see, because this bench is going to sit only half Wednesday, so it will be what?
5th November. It would be 5th.
List the matter on 5th. On 5th,
Maybe, Lordship.
5th November 2024.
Obligation. June 5th, Lordship.
May it please your lordship. Lordship, I would like to mention item number 4.
4.
I will pray before the lordship, this matter may be adjourned. I have taken consent from the respondent.
Okay.
This matter,
Mr. Learned counsel for the petitioner has prayed for adjournment of the matter with the consent of the respondents. In view of the above list,
after 4 weeks. Lordship.
after 4 weeks,
4
after 4 weeks.
Obliged.
My lord, having to mention item number 13.
13.
Yes, my lord. This matter will be listed after 2 weeks.
You are for the petitioner?
Petitioner, my lord.
Okay, Mr. So-and-so, learned counsel for the petitioner has prayed for adjournment of the matter. What about the respondents, which is not objected by the counsel for the respondents? In view of the above, list after
2 weeks.
2 weeks.
May I read a mention? My lord, I beg to mention item number 10, my lord. Here, my lord, we need some instruction, my lord. So this matter will be fixed after 2 weeks, my lord. This is arbitration appeal, my lord.
You are for the appellant?
Yes, my lord.
My lord, I am for the respondent. My
Respondent.
lord, I have just been informed
But my lord, there are some developments. My lord, if say, if it is adjourned for 2 weeks, my lord, could status quo as on today be granted, my lord?
Pardon?
Could status quo as on today?
Status quo.
But my
Now,
lord,
this is an appeal against the,
arbitration.
what? This is an
Arbitration
appeal.
award. Arbitration, my lord, section 9 petition, my lord,
Okay, so this is an appeal against the judgment of
of the learned district judge.
district judge.
My lord, what the learned district judge said was that there be a joint measurement. And if we are agreed by the joint measurement, my lord, the dispute review expert we call, the dispute review expert, if he grants anything, till the payment is made, because this is ad interim till the arbitration takes place, my lord, by the till the matter is considered by the arbitral tribunal. So till the payment is made, my lord, the second phase of the work be not, my lord, executed. My lord, here what our contention was.
Who has to execute the work? You or?
No,
My
the
lord, the
different
pay.
contractor.
My
The
lord,
different
reason-
contractor has to execute the work. There is already a direction by this honorable court
Hmm.
that the joint measurement has to be taken and thereafter the site has to be handed over.
Hmm.
The joint measurement has been done, but till that
Handing over is not done.
they are not handing over. In fact, we are contemplating to file a contempt petition, madam.
Oh.
my lord,
Because-
So there cannot be any status quo order, madam.
Case 10.
Yes, ma'am. There cannot be a status quo order. They want the status quo order today because they are,
So that you don't hand over.
my lord, the
Yes.
fact is, the actual
that
fact,
will
my
be
lord,
in violation of this honorable court's order.
my lord,
Let's
the
say this
actual
court's
fact,
order.
Yes, my
Okay.
lord.
the fact remains, my lord, that we have completed a portion of the work. My lord, that same work, it is actually a case of corruption, my lord. The same work which we have already done, they are handing it over to a different contractor just to take the bids.
No, no.
But
No.
if there's an order.
Already
of
a
this
different
court,
tender has been
let's see
floated.
If there's
My
already
lord,
been an
different
order.
tender for the same work which we
No,
have already done.
Okay.
It's
Uh,
construction of a.
Is an order dated 2103.
Yes.
Okay, which portion is it that this court has passed an order?
My lord.
My lord, may I-
Read the portion. Is it the last 3 lines? After joint measurement by the parties within 15 days,
Yes,
the appellate state authorities shall proceed with the execution of the tender dated
nine.
so and so.
Yes.
So
Mine.
you have to proceed
Yes.
with the execution of the tender
My
Yes,
lord.
after joint measurement by the parties within 15 days.
yes.
So have you made a joint?
Yes, we have met.
measurement?
They are
That-
still not allowing us to go ahead with the execution because they are not handing about.
But you have made the joint.
The joint
measurement,
measurement
isn't
has
it?
been done, my lord.
Then after the joint measurement,
My
the state authorities shall proceed with the execution
Exactly,
of
my
the tender. Then we
My lord.
cannot have status quo when
Yes,
there's a water
My
like
lord.
this.
My lord. But
Anyway.
the fact, my lord, is that,
Mhm.
my lord, till the arbitration, we have already applied for, my lord, appointment of the arbitrator.
Hmm.
The arbitral tribunal has to consider the matter under section 17.
Yes.
So
Yeah.
till the arbitral tribunal, my lord, considers the matter, because they have to appoint the arbitrator, which they have
No,
done.
we'll fix a short date.
My
Yes, ma'am.
Okay, without having a status quo, because that would be again conflicting the order of
Yes,
this
madam.
court, isn't it?
My-
Now who has prayed for adjournment? The appellant?
Yes, my lord.
Appellate.
Let it be fixed on my lord.
Okay, Mr. So-and-so, learned counsel for the appellant has prayed for adjournment of the matter. While Mr. P.D. Nair, learned counsel for the respondent, read that a short date may be fixed. In view of the above, list on
11. 11.
My lord,
11th
the-
November?
my lord, the DC has passed one order in between, my lord.
Okay,
This,
Let it be on 11.
Or fourth of them.
4th. Yes,
okay, 4th, 11th, 2020. Yes,
Fine.
always, ma'am.
let all this be considered. in the-
Mine. Deep here. I have to.
May I please log?
Yes,
My lord, in this writ petition, petitioner is, my lord, assigning the legality and validity
Hmm.
of bid evaluation report dated 9th October 2024, my lord. By which, my lord, the technical bid of the petitioner was, my lord, declared non-responsive, my lord.
Okay, so you had responded to the technical bid,
Yes,
is
my-
it?
yes, my lord.
And then you were declared non-responsive.
Yes, my lord.
While in
My lord.
actual, you have submitted all the required
Yes, my lord.
documents. Is
Is,
it
my
just,
my lord, may I take your lordship to the bid evaluation report, my lord? Is page 29, my lord. I'm sorry.
yes.
This is the bid evaluation, part 1, my lord. This is technical part, my lord.
Hmm.
My lord, the page 30 is the relevant, my lord. 30 is relevant.
Your serial number?
Yes, my lord, the serial number 4, my lord. MS
4.
Brew Enterprises, non-responsive. My lord, brief reason for responsive and non-responsive, my lord. By clause 4.4b, small b, my lord, Roman I of the ITV, my lord. This is the reason why my bid has been, my lord, declared as non-responsive, my lord. My lord, next, my lord, I take your lordship to clause 4.4b at page, my lord, 57.
57.
Page 57. What is the, my lord, this clause 4.4b, my lord? My lord, down below, my lord. 4.4b1, the key,
4.4b, small b.
yes, my lord. The key equipment for roadworks and field testing laboratories, my lord. My lord,
Okay, the
My-
key equipments, huh?
Yes.
Yes.
this, my lord, this is regarding my lord, say, equipments and machineries. My lord, the clause A, my lord. For roadworks, my lord, I have to submit, my lord, altogether, my lord, 20 numbers of, my lord, machineries. I have to show, my lord.
Hmm.
There is altogether 20 numbers of machineries with my firm, my lord, for the construction work, my lord. And thereafter, my lord, clause B, my lord,
Hmm.
field testing laboratory, my lord. This is the equipment, my lord, altogether 21, my lord. 21
Altogether 13, not 21, 13. Okay, yes.
field
yes, yes.
testing laboratory,
Yes,
B, my lord.
yes, huh.
21 number of equipments is necessary, my lord. Thereafter, C, my lord, other accessories, reagents, and glassware. There is altogether 13, my lord. There are, my lord, quantities has been given in right side, my lord. Right side of this, my lord, table, my lord,
Hmm.
quantities. My lord, accordingly, my lord, I have submitted all the required documents, my lord, showing my possession of these machineries and equipments and other accessories, my lord. And that, my lord, would find at, my lord, page 122 honor, my lord. 122, my lord.
Hmm.
122, my lord. Annex 8, my lord.
Hmm.
My lord, this is available, affidavit, by way of affidavit I have submitted, my lord. Availability of key items of contractor equipments. My lord, down below, my lord, there is certain columns and my lord, rows, my lord. My lord, I have given as per requirement, my lord. 20 number of, my lord, machineries.
21.
21 is laboratory equipments, my lord.
Okay,
And 20 is machinery, my lord. 20 number of machinery as per specification given by the, my lord, tender issuing authority, my lord. And my lord, from page 124 to, my lord,
Hmm.
194, my lord. This is, my lord, this is, my lord, my documents, my lord, showing that these machineries are owned by me and some are leased by me, on lease, my lord. This is sir from page 124 to 94, my lord.
Hmm.
It start from 122. My lord, 122, my lord.
The gist of your submission is
Yes.
that you have all the requirements which
Yes.
is required. In spite of that, you have been declared as non-responsive.
Non-responsive, my lord. That is my case, my lord.
Okay.
The
Yes.
whole.
So we'll issue notice. Heard, Mr.
My lord,
Yes.
my lord, this 122.
Page 122.
Yes, 122. Is a affidavit stating that he have possessed this document, machinery. But this machinery is suppose number one, truck mounted water tanker. He has two. He said two owned by him, but there is no supporting document except one invoice. That is page 124. Except this invoice, he have said that he said already owned. If it is owned, there has to be registration and all the documents. Except this document, there is no other document to support his claim. And second number, item number 3, pneumatic tire rollers. He has, that is also, he have furnished. No, second number, tandem vibratory rollers. It has to be the two. Again, he has submit one invoice for only one tandem rollers. There is a shortage of the machinery, so his bids was rejected on this ground only. So there is no any irregularity in rejecting his technical bids. So he has not submitted as per the specification given in the SBD.
Okay, in the specification, what is required?
Yes,
That you have to declare what you have and also file certain, isn't there?
Supporting
Anything else?
document, it has to be there. Suppose if I own a truck, I have to get submit a registration number also and insurance.
Yes, so what do you have to say to that?
Yes, my lord. So my lord, I will, my lord, submit in two-fold, my lord. First, my lord, as per my.
Anyways, we'll issue notice, you file a counter.
Okay, notice.
And then we will, this thing, it can be disposed of after hearing both the parties, I think.
Yes.
Isn't it?
My lord,
Notice.
my lord, there is interim prayer, my lord. My lord, finalization may be, my lord. Let short date may be given, my lord. Till then, my lord, it's my lord.
Short date will not pass an interim. In the short date, we'll see. Isn't
My
it?
lord, finalization, my lord.
This is all developmental activity in border areas.
But my lord, my bid has been rejected arbitrarily, illegally, my lord. Otherwise, I'm my lord.
That you have to show, that you have to show.
Yes, my lord, I will show, my lord.
Which has been countered. So let's see, we
Yes,
will
ma'am.
see in the next date. Okay, we'll fix a short date. Okay. Heard Mr.
H. Lampu.
H. Lamba, learned counsel for the petitioner, who has challenged the validity of the bid evaluation report dash part 1 dated 09/10/2024, whereby the petitioner's firm was declared non-responsive in part 1 within brackets technical part of the bid close bracket by the Standing Technical Bid Evaluation Committee in pursuant to the NIT dated 11/03/2024, invited by the Executive Engineer slash DPIU dash Roman 2, Rural Works Development Department, Rural Works Department, okay, not development, Hayungliang, Anjo District, Government of AP. In items rate bids in electronic tendering system for construction of works from L025 dash Hayungliang Changlagam BRO Road to Mithumna within brackets 2.80 kilometers and the maintenance for 5 years, having package number AR/16/02/866 under the Vibrant Village Program within brackets VVP. The learned counsel submits that in spite of him furnishing the information that he has all the required materials given in required under, okay, not given in, required under clause 4.4b within brackets B, then between brackets Roman 1 of appendix to ITB as regards to the equipment / machinery. However, his bid has been rejected on being non-responsive. Notice be issued, Mr. So-and-so, learned government, standing
Council for
counsel for
RW.
the so-and-so department accepts
Respondent one.
notice. Requisite copies of the writ petition to be duly furnished to the learned counsel for the respondent, private respondent.
They are private respondent,
Notice be issued to the private respondent number
4 and 5, madam.
4 and 5 through registered post with AD within 3 days, returnable by 3 weeks as well as through usual process. List after 3 weeks. Yes,
My lord, since there is, I have already made a private respondent, those who are, my lord, qualified in technical bid, my lord. And my lord, their financial bid might be open, my lord. Therefore, my lord, in my humble submission, my lord, let this, my lord, tender process should not be finalized, my lord. Let the
Yes,
afford date may
the-
be given, my
the
lord.
tender, meanwhile, the tender process should not be finalized, okay, till the next date of this day. Yes.
Like, give me.
Yes.
My lord, I beg to mention that that I have not made necessary party or the respondents. Therefore, this matter may be allowed to withdraw
Okay.
and liberty to
Mr.
file a petition.
Heard, Mr. Your good name?
Tony Gammi.
The government learned counsel for the petitioner, okay, who has prayed that he may be allowed to withdraw the instant writ petition due to certain technical defects and that he may be allowed to file afresh if so advised. In view of the above, okay, cancel the is so advised, okay? In view of the above, the learned, the instant writ petition is allowed to be withdrawn and with the liberty to file afresh if so advised. Accordingly, WPC number 465 of 2024 stands disposed of on withdrawal. Yes. Sorry. Yes.
My lord, this is relating to non-payment of solution.
Okay. The award has been given to you. Award money has been given.
That has been given to me,
Okay.
but solution has not been paid to me. My lord, this is a settled position of law that the landowners are entitled to get solution with interest.
So have you made some representation for payment of solution?
No,
Have you informed?
notice has been served.
Yes, what do you have to say? Any
My lord-
issue notice? Let them
My
know.
lord, this is not a case of, my lord, that,
Awarded amount has been given.
no, my lord. This land was acquired under 1940 Jum Land Act, wherein, my lord, there is no scope of, my lord, solution. Had it been in new act, Lara Act 2013, they are entitled for that solution. Now, entire matter is before the Supreme Court, madam, whether they are entitled or not.
Okay. Oh, so it has been acquired under what act?
1947 Jum Land Act, madam.
Okay, Zoom
Section
Act.
10, yes,
So the matter is pending.
pending before the Supreme Court, my lord.
So
So, at this
then,
instant, let notice may be issued, my lord.
we'll issue notice,
Notice.
okay.
I am for
Okay,
two and
heard
three,
Mr.
Yes, Goyam.
S. Goya, learned counsel for the petitioner, who submits that the landed property of the petitioners located at them along Joram
Joram Coloring Road.
to Koloriang Road have been acquired by the respondents under the Transnational Highway. However, though the petitioners were paid compensation for the acquisition of their land, they have not been paid the solicium as entitled by law. In view of the above, the petitioners have the instant writ petition for payment of the solicium. Okay, then heard issue notice, Mr. Swenson, learned counsel for the respondents accepts notice on behalf of the state.
I'm for respond number 2 and 3, madam.
2 and 3. Okay, one, Mr. So-and-so, for.
One, madam. For respondent number 1.
For non-respondent number 1 and Mr. Imwatu for respondent number
Madam, respondent number 4, madam.
4. Requisite copies of the petition to be duly furnished to the learned counsel for the respondents. List after
4 weeks, madam.
4 weeks.
4 weeks.
Obligation.
Please, your lordship.
Yes.
This is the matter about the arbitration, about the pay anomaly.
Oh, yes, yes, huh.
My lord. My lord, on the last occasion, I had produced one document of the high-level standing committee, which the government has been pleased to bring it on record by the last affidavit, my lord, filed on 22/10/2024.
Okay. So it appears that steps are going to be taken.
My lord, they have approved, if my lord comes to the affidavit,
Where's the affidavit?
the last affidavit, my lord, filed on 22nd of October by the finance department, my lord.
Yes.
Wait, let me just come to the affidavit. What do the finance department say?
They have brought on record the recommendation of the high-level standing committee and
The last affidavit.
22nd October, my lord, last one. No, the affidavit.
Yes.
Yes, my lord, may come to page 7 first, para 3. The deponent begs to state that by letter dated 17/9/2024, the Department of Finance has forwarded the recommendation of the high-level standing committee on pay anomaly on 4/7/24, which was duly approved by the government. Now, this one, lordship will find the typed copy at page 10. Photocopy is at page 9. In the
Yes.
table, my lord, lordship was pleased to go through this on the last date. This is not a case of pay anomaly, but basically a case of upgradation of pay. There's already a resolution on the meeting dated 17/3/2020 in the Guwahati High Court, Itanagar Permanent Bench, in the presence of Honorable Chief Justice, Justices of the High Court, whereby enhancement was allowed. HLSC recommends for consideration of the case, the Law Department in consultation with the Finance Department to follow the laid down procedure for upgradation. So now it's only the clerical thing which has to be done.
So
And
can
they
you
say,
close the writ petition?
my lord, my lord, my lord, my lord.
Okay, you have agreed to the prayer made by the petitioner.
Yes, my lord.
That his pay should be in par with the
Assistant registrar.
Assistant registrar.
assistant registrar.
Yes, ma'am.
There's one background, my lord, for dictating the order lordship may like to consider, my lord. My lord, initially, the pay of the assistant registrar was below that of the civil secretary,
registrar,
assistant
okay.
registrar and others. My lord, they had, if lordship before that comes to page 54, I'll just show, of the writ petition.
Okay. Yes.
This is an order, my lord, showing the pay drawn by all the staff of the registry of this bench. Serial number 3 is the assistant registrar. My lord will see pay band 3, rupees 15,600 to 39,100 plus grade pay of 5,400. The same scale and same grade pay is in serial number 4 of the librarian. Same pay band and grade pay. My lord, this is also in line with the Guwahati High Court rules 1967, which say that the assistant registrar's pay scale and the librarian cum research officer's pay scale is one and the same. It's there in the rules. In fact, I've quoted that in para 17 of my writ petition. Now, after this, my lord, some of the registry staff, they had approached this honorable court, saying that their pay should be at par with that of the civil secretariat. Lordship will find that at page 56. There was a judgment.
Okay. Oh.
Now, I'll not bother Lordships, but Lordship may just come to page 58. There's a quotation from the Department of Finance counter affidavit. They say that with regard to the statements in paragraph so-and-so of the writ petition, the deponent begs to state that the law department, by their file number so-and-so, had sought approval of implementation of the Judges Committee report of the Honorable Judges of the Guwahati High Court, comprising of Honorable Justice P.G. Agarwal and Honorable Justice Ranjan Gogoi, regarding uniform, better and higher pay scales of the employees of the principal seat as well as other outlying benches, including that of the Itanagar bench of the Guwahati High Court. The Finance Department, vide UO number so-and-so, dated so-and-so, had accorded in principle concurrence for implementation of the said uniform pay scales as per the Judges Committee report in the Itanagar bench of the Guwahati High Court. In view of the above, it is apparent that the prayer of the petitioners in this writ petition had already been accepted by the government, and therefore nothing survives for adjudication of this court. So-and-so. In view of the above, and as agreed to by learned counsel for the parties, this writ petition stands disposed of with a direction upon the respondents to give effect to the upgraded pay scales with grade pay to the petitioners in their respective categories, giving effect to the same from the date of this order, that is 15/6/2017. It is further directed that financial benefits be made available to the petitioners within 60 days from today. To avoid confusion in the matter, it is provided that the Joint Registrar of the Guwahati High Court Itanagar Permanent Bench would be entitled to the pay scale with equivalent grade pay at par with the Joint Secretary to the Government of Arunachal Pradesh. The Deputy Registrar of the Guwahati High Court Itanagar Permanent Bench would be entitled to pay scale with equivalent grade pay at par with the Deputy Secretary of the Government of Arunachal Pradesh in the Civil Secretariat, and the Assistant Registrar of the Guwahati High Court Itanagar Permanent Bench would be entitled to pay scale with equivalent grade pay at par with Under Secretary of the Government of Arunachal Pradesh. Writ petition stands allowed. After this, my lord, what they did is, even though the Assistant Registrar and Librarian, they enjoyed the same pay scale and grade pay, only the
Assistant
Assistant
Registrar
Registrar.
was upgraded.
And that is the cause for this writ petition. Now, this one, Lordship may come to page 76. After implementation of this order, what was the difference, my lord? My lord finds that?
Yes.
Yes. Serial number 2,
Assistant Registrar.
Assistant Registrar. Pay band 3 is the same. 15,600 to 39,100 plus 6,600 is the grade pay at par with that of the Civil Secretariat, Under Secretary. Now, serial number 3, Librarian cum Research Officer, same pay band, 50,600 to 39,100, but the grade pay is the earlier grade pay of 5,400. This was not increased.
Okay.
This ought to have been made 6,600.
So it's only the grade pay.
Only the grade pay. So that is, and this matter was considered by the Judges Committee once again, my lord, on my representation.
Is the copy of the Judges?
Yes, my lord, page 94.
Yes.
This was the agenda note, my lord. My lord may come to, directly come to 1, 2, 3, and 4. One is a reiteration of pay band of employees of the Guwahati High Court Itanagar Permanent Bench is at par with the employees of Civil Secretariat. The post of Librarian cum Research Officer is neither available in the Civil Secretariat of Arunachal Pradesh nor in the Department of Public Libraries, Government of Arunachal Pradesh. Then serial number 3. On careful perusal of the representation and documents appended thereto, it appears to me that the grade pay of the Assistant Registrar, who was initially drawing the same pay scale with the Librarian cum Research Officer of this High Court, has now been enhanced to rupees 6,600 at par with the scale of Under Secretary of the Civil Secretariat. And therefore, subject to wisdom of your esteemed office, I am of the considered view that Librarian cum Research Officer would also be entitled to the enhanced grade pay of Assistant Registrar of the outlying bench. Now, this resolution was taken by page 96. My lord, in consideration of the registry's note dated 25/2/2020, as well as the reply by the Registrar Itanagar Permanent Bench, the prayer made by Sri Rajiv Kulta, Librarian cum Research Officer of the Itanagar Permanent Bench, for enhancement of pay scale at par with the Assistant Registrar of the Guwahati High Court Itanagar Permanent Bench at Naharlagun is allowed. Registry is directed. This has the approval of Honorable the Chief Justice. My lord, but though there have been letters, communications between the registry and the secretariat, nothing had transpired till. So that is why
So finally
they have agreed.
They have agreed.
My lord.
Yes.
So,
So we will allow this thing, we'll pass the order.
my lord,
Okay,
my lord,
we'll dispose it
from
of-
as on date, my lord, when the
Maybe
assistant
okay,
from 15th,
from the date when the assistant registrars
lord.
were enjoying
Yes,
the
madam.
pay scale.
because now,
Anything to mention on that?
because now, my lord, I have got the NSCP. So
Hmm.
now in any case, I'm getting that. But the deprivation was from
So-
15/6,
15/6 is the date when
2017.
the assistant registrars had enjoyed.
My lord, I'll
So-
only be entitled to arrears.
Okay, anything on that?
No, my lord. My lord, since he is already getting the pay scale because of the MSCP, the only left out is the area only, my lord.
Arrear.
Now the period, my lord. Now you lordship to say from which period he is entitled, my lord. Period, my lord. Now, my lord, as per this regulation, it was adopted
So let's look
2020.
at the resolution.
Regulation, yes,
Page 98, my lord.
98, 96 or 90.
96 is agenda. Yes, 96
Agenda with
onwards.
regulations, all right.
Okay, 98.
Sorry, my lord. 96, 96, 96.
Let's be clear on that, yes.
Yes.
Page 96. So what, the registry, Tanagar bench is to move the state government accordingly.
My lord.
Yes.
My lord, prior to this this is made on the basis of the agenda note, serial number 3 of the agenda note. It says it has now been enhanced, meaning thereby that the discrimination which was made between the assistant registrar and the librarian, which is not there in the High Court rules, that is sought to be corrected. So it has to be from the date when the assistant registrar grade pay was increased. Serial number 3 of the agenda note at page 94, my lord.
No, that is not given. From which date it was given effective?
But that has to be understood, my lord,
That was
because
asking for.
because of the High Court rules, my lord.
Okay, let's read the page 94,
My
serial number 3.
Serial number
again.
On careful perusal of the representation and documents appended thereto, it appears to me that the grade pay of assistant registrar who was initially drawing the same pay scale with that of librarian cum research officer of this High Court has now been enhanced to 6,600 at par with the scale of undersecretary. And therefore, subject to wisdom of your esteemed office, I have the considered view that the librarian cum research officer would also be entitled to the enhanced grade pay of the assistant registrar.
So they have to be placed in par with the assistant
Yes, my lord.
registrar.
From the date
Yes.
in which I have been deprived, from which I have been deprived, though the High Court rules specify the same pay scale.
If they have to be in par, they have to be equal.
Malad, there are two things.
Hmm.
From which date, my lord, he has been deprived, and from which date, my lord, now enhancement has been increased to 6,600. Now this period has to be taken care of, my lord. Now whether it is the same date or same year or not. my
Okay,
lord.
let's look at the
Same here.
opinion of the
Because this regulation
the
adopted by
matter
the
was placed before the pay alimony, isn't it?
High level standing committee.
high level standing committee.
So what do they say? Anything? Nothing?
They don't say anything, madam. They say it is allowed.
They only say, my lord, this is not a case of pay anomaly, but it's a case of upgradation of pay.
And they refer to the resolution of the judges committee, which has the approval of Honorable the Chief Justice. That's 17.3, which Lordship has already read. Now, madam, that is why I give a background that it was earlier the same, but because of the order of the Honorable High Court, because at that time it was the assistant registrar, the deputy registrar, and the joint registrar who had approached. They say that the scale of the assistant registrar
So they missed out the librarian.
librarian, because he was
The
not there.
librarian-
He was not there in the writ petition. In that writ petition, he was not there. But when the equivalent pay scale of the assistant registrar is enhanced, since the High Court rules provide that the assistant registrar and the librarian enjoy the same pay scale.
Where's that?
The High Court rules.
You lordship may kindly mark this one, page 96, my lord, when this
Okay.
regulation was adopted, this is 17/3/2020. Perhaps, my lord, you will be entitled from this period only. Because here is the, he has been allowed, my
My
lord,
lord,
not prior to that.
then
my lord.
that would be, my lord, a violation of the High Court rules itself.
No,
that is
regulation was
one
adopted
issue.
allowing the prayer made by the petitioner. my lord.
Because, my lord, I was not granted. It is the registry and the government.
So the assistant registrar, they enjoined the said upgradation from which, the pay scale.
Up
from
to
which-
50, from 15/6 to 2017. If my lord comes to the order of the High Court, my lord. The High Court's order, my lord.
The passed by Justice.
Page,
Commission.
yes, my lord, page 59, the operative portion.
Yes, so they were given retrospective.
Yes, my lord. It
okay.
starts at page 58, para 8, my lord. In view of the above, lordship finds that. Page 58, para 8. In view of the above and as agreed to by the learned counsel for the parties.
Okay, then let's look at your prayer
My
in the writ petition.
My lord, my lord. My prayers start at page
What did you pray
42.
for? Page
Page 42, my lord.
42. Yes.
Prayer A,
Uh,
mandamus to enhance the pay scale of the petitioner in the post of librarian cum research officer of the Guwahati High Court and its Itanagar permanent bench to bring it at par with the assistant registrar of its registry and its counterpart in the civil secretariat under secretary to the government of Arunachal Pradesh, as approved by the competent authority of the Guwahati High Court with effect from the date of enhancement of pay scale of the said assistant registrar, that is 15/6/2017. Made wide order in file number so and so dated 14/7/2017. And my lord, prayer B, my lord, is for arrears. So that is
So
my,
he has already mentioned these prayers. It's not something that has come.
and
out
they
of-
have not
Yes,
objected to in the
yes,
affidavit.
Yes. Okay, so I'll pass the
My
order
lord,
accordingly.
my
I think
lord,
it's clear in your prayer.
My,
Yes.
my, deeply,
Allowed and disposed. I'll pass the order later.
my, deeply.
Hmm.
This matter, instruction was sought from us.
Hmm.
So more time.
Let's see, instruction means, what? Rejoinder affidavit?
No.
What?
We went to the.
Okay, no, it says here, para 6, last order. The learned senior government advocate shall send a downloaded copy of this order
Yes, yes.
to respondents number 2
Yes.
to 5. Who is respondents? So the department of, so you're representing respondents number 2 to 5, is it?
Yes, yes. That I have done already, but we need some more time.
So they need to take a decision. What is the matter about?
This is pension methodology.
Okay, pension. Okay, will not objected, will, Mr.
Dilona.
D. Lorna, learned counsel for the petitioner is present along with Ms. So learned government advocate for the state respondents. The learned government advocate have wait for further time to get instructions in the matter. In view of the above list, when do you? 4 weeks, pension matter.
3 weeks, lords.
You're not really pressing the matter anyway. List after that's 4 weeks.
4 weeks, 4 weeks. No less.
Thanks.
No, this item 7, my argument will cover. I think 8 was there might be a small factual difference. But then, the short question involved in this question, in this case is that there was an advertisement issued by the Director General of Police for recruitment of the constables of various categories under the meritorious sports person quota. So now what had happened was, in this case, the petitioner is a national champion, participated in the national championship of the carom board discipline. Then he also
Sports person.
a sports person. He was eligible. Then there is a form called Form 2. It's a mandatory, that I'll demonstrate, Then in that form, what had happened was the secretary of the particular sports organization has not put the seal. Now, to my understanding, it is a trivial in nature, my lord. In the advertisement, my lord, the word seal was not mentioned, my lord. But it is necessary that you should use that the seal of the secretary of the state sports association should be mentioned.
You're
So then
certifying that he supports
Yeah.
sports person.
Yes,
Okay, there's a quota for people from a sports.
correct. I'll demonstrate that.
Okay,
Then what had happened was, I was called, there was a call letter. I participated in the physical test, I qualified, and I stood at serial number 127. But suddenly, there was a call comes to me saying that, no, you will not be eligible for the Viva Voice test because there is a discrepancy in your form. And what is the discrepancy? The discrepancy is the form 2. There is a column, my lord. Correct. So, my lord, I'll just demonstrate from the annexures now, my lord. Kindly come to page 16, my lord. This is my credential, my lord. I am a national carom player, my lord. Annexure 1, my lord. It is described in para 4 of my read petition, my lord. Now, kindly come to an advertisement, my lord. This is important, my lord. It page 21. Advertisement for recruitment.
21.
Yes, my lord. Here, my lord, we'll kindly see eligibility. Advertisement is so and so, and under the meritorious sports police person, so and so. The serial number 2, my lord, bracket, sub serial 2 again. Constable, my lord, 70 to 20 years. In the remarks column, my lord will see relaxation of upper age limit for the meritorious sports person is given to the maximum of 5 years for general and 10 years for non-APST. That is 31. In Mizoram also, it is the same case, tribal that we come. Now, my lord, we'll kindly come to list of games. In the third, after this, so you know, there's a serial number 11, my lord, list of games. My discipline is serial number 12, my lord. The carom discipline, that is my discipline. Now, my lord, kindly see down below. Other eligibility, page 22, my lord. Serial number, my lord, 5, Roman 1, Roman 2, and then, my lord, there is a remark called note, NB. Now that it says, applications without all enclosures shall be rejected summarily. That is fine. Form 1, 2, 3, and 4 regarding medical certificates should be accompanied with the enclosures, and this certificate will valid only when signed. Manor will mark this. This is the bone of contention in this case. Otherwise, nothing remains from their side or from my side, my lord. All these certificate, my lord, second line, all this certificate will valid only when signed personally by the Secretary, National Federation, National Association, Secretary of the State Association, my lord. The word that seal is not mentioned, my lord. Although, my lord, in the form 2, there is a column for the seal, but that is not there, my lord. Now, once you have accepted my application, you have called me for the physical case where we have qualified, my lord. Now, in the, especially you have given the rider, a special rider, saying that you must only, the secretary of the international, national, or the state sports association should sign personally. The word seal is not there, my lord. Now, that is the only ground how my candidature sought to be rejected by them. Now, which is pending, my lord. Only this is the only criteria. Now, my lord, when we put on to that particular point, my lord, now kindly come to, my lord, annexure 4, my lord, page 38, my lord. There's a call letter.
Page?
Page 38, my lord.
38.
38. This is the call letter in my case, my lord.
Hmm. Hmm.
This is my call letter, my lord. Then what had happened is I have qualified everything, my lord. Now, what had happened, my lord, kindly see my representation. Thereafter, the subsequent development is at page, my lord, page 40, my lord, annexure 5, my lord.
Hmm.
Well, that second paragraph, my lord,
Hmm.
is important in this case, my lord. That it is pertinent to mention herein that despite being qualified in PST/PET/ document scrutiny on 9/6/2023, now your good office refused to issue appointment letter to the undersigned on trivial ground of not affixing a seal in Form 2, which is no fault on my part. Be that as it may, my only contention is that had it been the criteria for rejection of the candidature, my candidature would be rejected during scrutiny, and on 9/6/2023, instead of listing in the accepted and qualified candidates. Well, that is what, my lord, is the representation from the day one my stand has been, my lord. Now, kindly come to the impugn order, my lord, at page annexure 6, page 42, my lord.
Hmm.
Now, my lord, it says, the reply is, reference to the subject mentioned above, I am directed to inform you that your representation has been examined and found that the original Form 2, which was submitted by you with the application form, has no stamped official seal of the Secretary of Concerned Association. Now, well, there is no quarrel at all from their side, also from my side. But now this has become a bone of contention, my lord. The bone of contention in the form that the seal was not there.
So is the copy of the Form 2 here? No.
No, it is there, my lord. That kindly come to the affidavit filed by R3, my lord. The Home Department, my lord.
They have enclosed the Form 2, is it?
Correct, correct.
Hmm.
Annexure 1 series, my lord. Hmm.
4/6. Ah.
My lord, will see like
Where's the Form 2? Page?
form to page 6 of their.
Page 6. Now in Form 2.
Yes, my lord. Now, my lord, this is
signature. Okay,
certified.
there's a space here for seal.
Well,
Ah.
down below, kindly, after the place and date,
Hmm.
there is right, lordship will find signature. Their name is Yarda Tajo, designation secretary, Arunachal Kerala Association, Itanagar. Madam, then the seal is not there. Then I concede there is no seal below. So there, that is one aspect. Now, now there is a writer below in the bottom note. This certificate will be valid only when signed personally by the secretary of the association. Now, this suffices my contention. When the secretary has signed, he has forgot to put the seal, then it's of no fault of mine, my lord. Therefore, the state, my lord is aware. When we read the concept of state right from Aristotle, Plato, and so forth till Machiavelli, in that, my lord, it has always been talked about state as a welfare state. Now, welfare in the terms, my lord, is absolutely, my lord, will file in the preamble to the Constitution itself. Now, we are in democracy, we follow the rule of law, we have the Constitution, and state is a welfare state. Being a welfare state or the model employer, my lord, they ought to have adopted some soft approach instead of rejecting. Where this boy will go, my lord? After all, he is a meritorious sportsperson. His credential is not being disputed by anyone, my lord. So therefore, my request to the learned additional AG would also be that, allow this. After all, this poor fellow has qualified. They are post also, my lord. Except for the seal, my lord. Simply, my lord, the Home Department can do is, my lord, call the secretary of that association, Mr. Yarda Tayo, to their office. Is this your signature? Why have you not put the seal?
Okay,
Then
now
ask
this
him.
person, the secretary, he's not a party in this instant writ petition, is
I
he?
think we have not made it.
You
We have not,
been made
we
a
have not
party?
made it. No, because it is there. So therefore, accordingly, kindly come to my rejoinder para 4, Lord.
Page
Page 2,
2 of your writ
my
petition,
rejoinder, Lord.
of your writ petition or
My
rejoinder?
rejoinder, Lord.
No, the rejoinder it's here also. Yes.
So, my categorical stand that I have taken,
Hmm.
that the statement made in paragraph 8, well, their contention is in the paragraph 8, Lord, that I am rebutting now. That the statement made in para 8 of the affidavit in opposition is not true and are hereby denied by the answering deponent. In this context, your humble deponent begs to state that the Form 2 will be valid only when signed personally by the Secretary of the State Association. And in the case of petitioner, the Form 2 of the petitioner has been duly signed personally by Sri Yorda Tayo, General Secretary, Arunachal Karam Association, which is a Karam Association of Arunachal Pradesh. Moreover, it is apparently showing in Form 2 format that, that which I have described. Note, this certificate will be valid only when signed personally by the Secretary of the State Association. Moreover, Sri Yorda Tayo, General Secretary Arunachal Karam Association has issued to whom it may concern certificate,
Hmm.
dated 4/1/2024, whereby he is confirming that Form 2 certificate dated 22/7/2017 was issued and signed by him personally in favor of the petitioner. Therefore, the question of invalid Form 2 submitted by the petitioner does not arises at all.
Hmm. So where's this?
That
may
kindly
concern?
come where is that certificate? Annexure 1, page 5.
Okay, here.
Yes.
Yes. Okay, here is there a seal here? To whom it may concern?
Association letter paid is there.
Huh.
In the letter paid, when the seals are not required also.
Okay.
But it is there, Karam Secretary, Karam Association, down below it is there. You have not scanned this page. No, sum and substance, as I have pleaded earlier, that state being a welfare state and a model employer, they should consider on magnanimity also, because where this boy will go, after all, he's a sports person. He has represented your state.
Hmm.
He has brought laurels to the state government and also publicized and popularized the state. Like, look, there are sports person of a caliber of a national level from Arunachal. On this count, I'll request the learned additional AG. Kindly request him to, I request him to seek some instruction as to whether his case can be considered on this ground. Because I have a solid case because secretary of the association has given the certificate.
Okay.
That is my argument.
Now, they have filed a counter already.
Counter. Yes.
So instructions has been received.
Received, only one count. In view of the stand taken by the Secretary of the State, that the form has genuinely been signed and issued by me. But in my
Okay, so in your reply affidavit, you have now enclosed
I have
to whom it may concern.
Correct.
Now, based on that, you are saying that he may get instructions. Yes, additional AG. They have filed another document which shows that the General Secretary has also informed that he is he is a person who has that qualification. So the Learned Counsel for the petitioner says that since this matter, okay, and the annexure number 1 in their reply affidavit has not been addressed by you in your counter affidavit, you may receive instructions.
My lord,
No.
difficulty is that, my lord, selection procedure
Hmm.
cannot be initiated for one person, my lord.
So it's complete or
It's
what?
already complete.
Huh.
That selection process has been completed. Now for one person, whether again a selection process can be initiated, my lord. Further, my lord, even though they have, this is after the rejection, they admit that there was no seal.
Hmm.
What is the requirement as per the form, as per the advertisement? I will demonstrate, my lord.
Mhm.
It does not say that seal is not required.
Hmm.
My lord, may kindly take up our affidavit, my lord. My
Yes.
lord has at page 6, my lord has seen there is no seal.
Hmm. No seal,
Ah.
yes.
In the bottom note, it says this certificate will be valid only when signed personally by the Secretary of the State Association. My lord, this is Form 2. My lord, heading for representing a state in India in a national competition in one of the recognized games sports. My lord, what is required that no other person other than the secretary
Hmm.
should sign it.
Hmm.
Even if there is a seal, but if it is signed by any other person, that
So
will not.
this is the general secretary.
Yes, and to demonstrate that, I will further take your lordship to the forms for the other categories also, my lord. My lord will kindly come to page 22. This is Form 1.
Hmm.
Form 1 is meant for this category for representing India in an international competition in one of the recognized games sports. This is Form 1. And here also, what is the requirement? Note, this certificate will be valid only when signed personally by the Secretary, National Federation / National Association. It has to be signed by no other person than the Secretary of the National Federation or National Association. It does not say that the seal is not required. It is only for the specific purpose that no other person than the secretary. Same thing in Form 2 at page 24, which is relevant for the petitioner. Here also, secretary, it said the certificate will be valid only when signed personally by the secretary of the state association.
Hmm.
No other seal is required. It doesn't, even if there is a seal and signed by someone else, not apart from the secretary by the president or other, that will not be. What is meant is by the secretary,
yes.
personally shall have to sign, no other person. It does not say that seal is not required.
Hmm.
When there is a format for a seal to be affixed, they have to affix the seal. This is the interpretation, my lord. It does not say that the seal is not required when if it is personally signed by the secretary. Form 3, same thing. These are Form 3. The certificate will be valid only when signed personally by the dean, director, or other officer in overall in charge of sports in the University of Science. Personally signed by dean, director, or other officer in charge. It does not say that if they have signed, then the seal is not required. Seal is the provision of seal is there, and they have to. How otherwise? How can the authenticity of this certificate be accepted, Malak, without the seal? We just by seeing the sign.
So basically, you're insisting on the seal because you want to prove the authenticity.
Yes,
of the signature.
Yes.
Isn't it? Now, in the affidavit in reply, to show the authenticity, there's an annexure which has been in.
My lord, at the time of filling out the form, or there should not be any mistakes.
Hmm.
There cannot be a correction to the mistakes after filling out the application forms for the recruitment. Otherwise, after the recruitment process has
Now it's
finished,
now it's finished.
yes, madam.
No, but that,
Recruitment process has finished.
No.
Now,
Appointments made
madam.
recruitment process is finished. That means they have been appointed. They can.
Yes, my lord, appointments have been made. My lord, there was an interim order by this honorable court in the next case. There were candidates who were already selected.
That will be subject to the outcome, is it?
No,
Or what is the order?
interim order was modified to the extent that post will be kept vacant.
Okay. So in the instant case, that's in the other case. In the
Yes.
instant case, post is kept vacant, nothing is there.
No, my lord, here, although there are the number of posts is more than the number of candidates, my lord. That is the another thing. His case cannot be singly made to be considered because already the other physical efficiency test, test has been done, madam.
He's been done. He also district took part and he was qualified, is it?
No, they were not allowed to.
Okay, in the physical, they were not allowed to take part.
Yes.
Is it?
Yes.
No, physical also, everything done.
No.
Except-
You are not allowed.
Well, not,
Not allowed to.
So now there's this dispute. He's saying that they had
No,
to
physical we have
take
done.
part
No.
in the physical test
Physical
where he
test was-
qualified.
But the learned additional age is correct. Physical part,
Yes,
I was
was-
not.
Okay. he
Not
did
allowed.
Now, my lord, very interesting. I was just flipping through the judgments. There is a apex court judgment. Candidature cannot be cancelled for trivial errors. That the judgment I will place, my lord. I think this fortifies my case. I'll just furnish it. That, my lord, the case in itself says it is by division bench by the apex court. The Supreme Court today allow a plea of a man aspiring to become a police constable whose candidature was cancelled by respondent authorities on account of an inadvertent error made by him while mentioning his date of birth in the application. But here, my lord, only the seal. So, my lord, date of birth is a crucial aspect. But here, only the trivial mistake. This judgment fortifies. I'll furnish, my lord.
Okay, so concerning this, no, see,
And my lord,
whether
second-
he belongs to the association or not, authenticity, that has been clarified in Annexure 1. Okay, your ground is that it is not authentic. For some mistakes, seal has not been there, others, there is, in fact, I have a feeling that this person, the secretary, should also have been made a party, and then he could have explained.
Yes.
Correct, my lord. If he comes, then again, my lord, now it is.
Then, the respondents can have it clear this thing. But since he has not been made a party in the affidavit in reply to your counter, there's a document which has been produced, which
My
was not produced.
My lord may direct the petitioner to submit an representation annexing this, and that representation may be considered. Annexing the
No, my lord.
document that has been annexed here with the secretary to consider. With the authority.
Dispose of the writ petition
Yes.
with an order that to consider the annexure, since the authenticity is the one which is questioned, then consider this and then take
Well,
necessary steps thereafter.
In the courtroom, my lord, it is a mind game.
Hmm.
Right?
So
mind game.
anyway, you give a copy of your authority.
Well, it is in the courtroom, my lord, it is a mind game. And exactly the learned additional advocate general has played with the mind. So now, if this writ petition is to be disposed of with a direction to submit with a representation, then and there it goes, my lord.
Oh, to consider, okay, forget about representation. What I'm saying,
No,
forget
look,
about
now-
representation. If dispose it in view of the certificate submitted by the secretary,
And then, okay,
in the reply,
That-
that only to consider. may consider. That can be done in view of.
Otherwise, what can be done is now in your reply, you have done this, okay? Now you get instructions based on this and the next
Yes.
court will decide.
Yes, madam. That can also.
In the meantime, I have.
Yes,
just-
yes, so
Yes.
in the next date, along with the authorities, will continue. In the
Madam,
meantime, you get instructions on this.
By
Then you-
next Monday?
Make it the next.
Next Monday.
This case is different than the other case, madam.
There's another case also,
Yeah.
which is,
In item 7, we will take instruction. Let it be after 2 weeks, madam.
Monday.
No,
Monday.
1 day.
no, we'll make it after 2 weeks, but your case, what is your case? Because they have been clubbed together, have they?
Yes, my case is, my lord, the fact of my case is that, my lord, the petitioner hearing has been rejected and thereby from participating in the physical efficiency test. But some other candidate has been allowed to participate in the same examination on strength of the same certificate. But the
Okay, his certificate was rejected, while the certificate of the others was accepted.
allowed, accepted.
And it was exactly the same?
Yes. And now I have obtained the documents through RTI. Now I would like to find.
Place it
that-
through additional
yes,
affidavit,
additional-
okay. So we'll leave it at that. Now, in item number 7, I heard Mr. T. Tara, learned counsel for the petitioner, along with Mr. So-and-so, learned additional AG for the state respondents. Having heard these submissions made by the learned counsels for both the parties, it is seen that it is seen that in the affidavit, rejoinder affidavit, okay, filed by the petitioner, a document has been enclosed. Dated, what is your, to whom it may concern date?
Pardon, my lord?
Dated 04/01/2024.
Yes.
Issued by the General Secretary, Arunachal Karam Association. Certifying that the Form 2 dated 22/07/2017 in favor of the petitioner was issued by the General Secretary, Arunachal Karam Association. The learned additional AG has prayed for time to get instructions with regards to the said document dated 04/01/2024. In view of the above, this after 2 weeks. Okay. Then in 8, heard Mr. So-and-so, learned counsel for the petitioner, who submits that he may be allowed to file an additional affidavit to bring on record certain documents which were obtained through RTI regarding the instant case. In view of the above, this the matter after 2 weeks.
Interim is your interim.
There's an interim.
Modified interim order. There is a modified interim order. This interim order is meaningless.
Seats, well, the posts were kept vacant.
Okay. Meanwhile,
Modified interim
the
order.
interim order dated. They must have a date if it
Yes,
has
my
been
lord,
modified.
Modified, my lord, I am.
Interim order dated. When was the modification?
By an IA.
If I may, my lord, that interim order is not reflected even in the online.
Okay, meanwhile, the modified, we'll just make it interim order
It's in
passed
the
by
IA.
this court in the connected IA is to continue till the next date of listing.
It can be listed together.
Yes.
And along, much of it.
Yes, what is the stage?
My lord, here the pleadings is complete, my lord. The petitioners, my lord, they are running away from this case, my lord. We have challenged the maintainability of this writ petition, or this writ petition may be dismissed, my lord, or non-prosecution, my lord.
So you have the standing counsel?
Yes, my lord.
Okay, Mr. B. Picha.
Yes.
Learned standing counsel for the rural department is present, while none appeared for the petitioners. In view of the above, list the matter after.
My lord, this may be dismissed, otherwise, my lord, I will submit, my lord. The
No,
facts of the case, my lord.
We
May I?
we have to hear the other party, isn't it? So
I
they say-
will project their case
Because
from
they
their
were
writ petition.
present in the last date also.
I will
It's not
project
as
their.
if they have been continuously.
My lord, may I,
absent.
my lord? From, my lord, 17/9/24, my lord, they are running, my lord. We have raised
But-
the issue of maintainability, my lord.
But they were present on 4th, okay? So list, they were present in the last date in view of the above, due to the absence of the petitioners, list after 2 weeks.
My lord, next Monday, my lord, there is some pressure we are giving, my lord.
Okay,
We are having.
list on, give us.
Monday.
Give a date,
This Monday, my lord.
not this Monday, on a 4th. Okay, list on 4th, 11/2024.
My lord. Okay.
Yes. Yes.
Matters, my lord. My lord, so far the actions of pleading in this case, I have received the affidavit in opposition filed by the respondent number 1 to 5.
Oh.
So I will show the time to go through the affidavit in opposition filed by the respondent number 1 to.
Oh, so,
Four.
so you want to file your rejoinder?
If so advised, but I have
Okay,
to go through.
okay.
So
Heard Mr.
Shimodi.
C. Modi, learned counsel for the petitioner, who submits that he has recently received the counter affidavits filed by the respondents number 2, 3, 4, and 5.
Yes.
What about 1? Not required. Hmm. Okay, 2, 3, 4, and 5. The learned counsel for the petitioner has prayed for time to get instructions whether a reply affidavit is required with regards to the counter affidavits filed by the respondents. In view of the above, list after 2 weeks.
Here also, my lord, I
Same.
have received same.
Okay. Same. order.
Yes, except the respondent number 4 in place of the 6.
Two,
Respondent number 4 is yet to file.
okay, so 2,
1 to
3,
3 file.
2, 1 to
3
5.
file, yes.
Wait. 1, 2, 3, and 5.
No, up to respondent number 4.
Okay,
We have filed
1
one.
to 4.
4 has already. 1 to 3 has filed. 4 is yet to file. 4 is the private respondent.
Okay, so who is representing respondent number 4?
In the last occasion, the council
Comment
was
section.
there.
So, okay, so then will Mr. So-and-so, and counsel for the petitioner is present, who submits that he may get instructions whether he wants to, whether he's required to file a rejoinder affidavit to the counter affidavit filed by respondents number 1 to 3.
Three.
It is seen that none appeared for respondent number 4. That they have to file their counter affidavit, isn't it? Anyways, in view of the above, list after 2 weeks.
All right.
Yes, that's the service.
That's the service, my lord. We have already filed, my lord, the
Affidavits?
affidavit, my lord. So, my lord, that aspect is completed, my lord. In fact, my lord, they refuse to my lord, accept the copy of the Dusty service, saying that we are not responsible for the, my lord, for respondent number 2, my lord. So therefore, my lord,
Who are the respondents?
my lord, respondent number 2, as per the, my lord, on the last occasions, my lord, we implemented, my lord, one of the respondent is respondent number 3, and respondent number 3, namely, my lord, Srimati YW Ringu, my lord.
Respondent number 3 is
Respondent
needed.
number. Now the respondent number 3 has filed an affidavit saying that no, we are not responsible for the, we are not responsible and connected at all in this present matter, my lord. And the affidavit, my lord, if lordship peruse the, my lord, the affidavit filed by the, my lord, the respondent number 3. For a moment, my lord, may I take your lordships to the affidavit filed by the respondent number 3?
Yes. So they have not come. They are not represented today.
No,
Whatever
my lord,
affidavit
they are
they
represented.
filed, they should be
I'm
represented.
yes,
The respondent number
yes.
3.
My lord, I'm-
1 and 2.
1 and 2, my lord, we have taken already service, and to that effect, my lord, we have also filed additional affidavit. An additional affidavit, my lord, that may be called for, my lord. Just this morning one, my lord,
Where's
otherwise
the
this is the
additional
copy.
affidavit?
They refused to, my lord, accept the copy, saying that we are not connected to this department, my lord. Respondent number 1 and 2, my lord. So therefore, my lord, the one must be there who is responsible for all this department. So therefore, my lord, at this stage, may I pray, my lord, the landed chief secretary may be, my lord, the call for, my lord.
Well, the government advocate.
My lord,
someone
my lord, my
represented-
another limb of submission is,
Oh.
as per the affidavit filed by the respondent number 3, just for a moment, my lord, may I take your lordship to the affidavit filed by the respondent number 3 at page number, my lord, 3, internal page 3, my lord, original page is page number 17, my lord, in continuations to this proceeding. Last paragraph, my lord, I'll skip other parts. First line of last one. Whereas, my lord, lordship is finding, my lord.
Page?
Whereas page number 17, my lord,
Oh.
affidavit filed by the respondent. Whereas the planning and investment department is being made by another secretary. The budgetary allocations of the fund is done by the planning and investment department, which is completely under their domain as per the rules of the allocation of business. Until and unless the fund is allocated by the planning and investment department, no amount can be sanctioned by the finance department, or the no administrative approvals of the fund can be provided by the finance department. My lord, next paragraph. In the present case, this by judgment and order dated so and so, the respondent number 2 and 3 have been directed to allocate the additional fund so that the pending liabilities of the petitioner can be satisfied. It is pertinent to mention then, herein then, the respondent number 3 in the judgment is the Secretary, Finance, Planning and Investment Department, Government of Arunachal Pradesh, Itanagar. Whereas there is no post, but either it should be the Secretary, Finance Department or Secretary, Planning and Investment Department, my lord. Now, my lord, I'll pause for a moment, my lord. Lordship may kindly peruse our application, the contempt petitions, my lord. Wherein, of course, my lord, finance word is also added, but the Secretary, Finance, my lord. If we read again, my lord, the Secretary, Planning and Investment is the correct authorities, my lord.
Wait, is there such a post?
My lord, they are saying that there is no post, my lord. Therefore, they refuse to accept, my lord. So therefore, one must be there, my lord.
No, see, in the contempt, let's see the parties.
Party, my lord, respondent number 2. Respondent number 2, my lord.
Wait, let's see the contempt petition. Who have you made the parties? So respondent now, Secretary, Finance, Planning and Investment.
Yes. Of course, finance is used, my lord.
Finance is used.
But
finance is used, but the
planning and investment is also there, my lord. Planning, my lord, if lordship see, para 2, Sri so and so, presently serving as secretary. Serving as secretary. Finance, Planning and Investment, Government of Arunachal Pradesh, Civil Secretariat, Itanagar, my lord. Now, my lord, the affidavit filed by the respondent number 3 is clear. That secretary, of course, my lord, word finance is also added. But planning and investment is also, my lord, one of the respondent number 2, my lord.
So it's the same person or what?
Yes, my lord.
He's in charge of the Secretary
Earlier
of
he was in
Finance
charge.
or Secretary of Planning and Investment?
Planning, Malad secretary, finance as well, but planning and investment, man.
So this thing is against the Secretary Finance or Secretary Planning and
Yes,
Investment?
madam. He is one of the respondent as per the directions of this honorable court. He is one of the respondent number 3, madam. Respondent number 1 and in original writ petition, madam, respondent number 2 is the madam, the principal secretary, madam. Finance word is used, planning and investment, madam. Now, as per the affidavit filed by the respondent number 3 is very much clear that there must be secretary, planning and investment, madam. Planning and investment department. So therefore, respondent number, principal secretary, of course, finance is used. Planning and investment is also included, madam.
No, so what is the post? See, there has to be a post, and as per the post, the parties have to be made. Okay?
Madam.
So he's saying that he is the finance secretary and also in charge of planning and investment. Is
Madam,
it?
planning and investment and finance, madam, as well, madam.
So is there such a post?
Yes, madam. Principal secretary, madam, and secretary, madam. As per the affidavit filed by the respondent number 3, if lordship read again, madam.
Let's see, I'm not understanding. See, because they have to be
Para-
addressed.
para-
See, they are government officials, they have to be addressed correctly
Correct.
as their post, okay?
Madam,
So you have to find out their
my
post,
lord, may kindly
the
peruse
designation.
my lord, may kindly peruse the affidavit filed by the respondent number 3
Three.
once again, madam.
Yes.
My lord, what it says, but either it should be the secretary finance department or secretary planning and investment department. And my lord, respondent number 2 is the secretary planning and investment as well as the finance, madam. Therefore, we have rightly, my lord, implemented as respondent number 2 as secretary planning and investment, madam.
So there is a secretary planning and investment department also.
My lord, as per this affidavit, it is clear that there is a post.
There is
Secretary,
a secretary.
secretary, what they are saying is secretary planning and investment, not finance. But what I am submitting is, of course, finance is added, but secretary planning and investment, madam. If lordship peruse the contempt applications, it is very much clear that secretary, of course, finance is used, planning and investment is also there, madam. One officer is holding so many posts, so many departments, madam. So therefore, this is one of the department, planning and investment. Secretary planning and investment is very much necessary party in the present manner, the contempt petition, madam.
So who's representing respondent number 3?
Madam, respondent number 3 is represented by my learned friend.
Lordship, there's no post, lordship, secretary, finance, planning and investment department, lordship. Planning, the finance department is a separate, lordship.
But it's against that person, isn't it?
Yes.
Against Mr. So-and-so. He's holding the charge of finance and also for planning and
Investment.
No, there's no one such as such.
He's not holding the post of that?
No.
Who's the person in charge of planning and investment?
That, lordship, I have to see it.
Okay, he's only secretary finance?
Secretary finance. The respondent number 3 is the secretary finance, lordship. He's a commissioner finance, lordship.
Commissioner finance.
Commissioner.
But as per this affidavit, secretary is very much one.
No, but as this thing, see, he's a government official. If he accepts the affidavit, the notice as it is, then he's also accepting that he's also in charge of planning and investment, which he is not.
Which is not correct.
Which he is not. You see? So he cannot take the responsibility of something which he is not responsible.
As per the
So you amend your cost title, it's as simple as that.
No, my lord, only yes, my lord, only striking out of
Yes.
out only
So
finance, my lord.
you make him, if you want the person to appear in his capacity as finance, then his name, then principal secretary, government of so and so.
My lord,
Okay.
what I'm coming,
If you don't want that, then the name of that person who is in charge of finance or whatever, investments, what is that department?
Planning and investment.
planning and
Planning and
investment.
investment.
My lord, this
Someone else is there? Not the
Yes,
same person?
someone is.
Then,
In fact, Lordship, on last occasion, Lordship, this honor could advise him to file an applications to implead that person.
My lord,
And but in
what I'm
spite
sa-
of that
my lord,
advice,
what-
Lordship, though it's not recorded, Lordship.
my lord, what I'm submitting is the persons who was holding the post of the secretary, planning and investment along with the finance, if he is not in charge of the finance, he is very much, my lord, one of the necessary party, my lord. In my lord, contempt petition, original contempt petition.
so you implead him as a different person, if it's a different person,
Earlier he was, my lord, if he's
but
not.
now it's not, so there's some change. So you have to file a
And,
fresh
and,
impleadment
my lord,
application.
as per the information, as per the information, nobody has been particularly posted there, my lord. So
Then
therefore,
find out who's in charge, then.
my
in
lord,
charge.
in charge is the respondent number 3, my lord. As per the information, he is holding also the post, looking after the post of the secretary, planning and finance, planning and investment as well.
In that case, Lordship, let him file rejoinder to my affidavit, Lordship.
Oh.
No,
Otherwise,
not
Lordship,
necessarily, my lord.
how
Is he holding in charge?
Yes.
post?
No. As per my affidavit, I am not holding the charge, Lordship. If that allegation is there, Lordship, let him reply to my affidavit, Lordship.
Not necessarily, my lord. So therefore, my lord, one must be there, my
Is
lord.
there anything
Direction
so
has
that
been given.
I'm holding the
My lord,
But since he's denying, we have to find out, maybe there will be an order showing that he's also
lord,
holding the charge.
yes, my lord.
Get that
Therefore,
order.
now, my lord, therefore, my lord, one of the respondent is respondent number 1, who is the overall in charge of the finance, planning and investment, my lord, entire thing, my lord. It's not that, my lord, I have used the word finance. Does not mean that, my lord, that other responsibilities and the other department which he looked into. For that matter, my lord, it is not always necessary to be mentioned, my lord. Whenever the one officer is holding, my lord, so many departments, my lord, the forced.
See, but since no one is there who is specifically holding that charge, then there should be a person who has to be in charge of that post
My lord.
for some time, isn't it? Then you have to show, otherwise.
My lord, respondent number 1 is the overall in charge, my lord. Principal secretary and principal planning and investment as well, my lord.
Who is the respondent number 1?
Respondent number 1, Sri Kaling Time, my lord.
So respondent number 1 is not represented today?
No, my lord. They refuse to receive my notice. That's the
So
service for
where's
which
the
I have.
affidavit?
Yes, I have
You have
filed
filed an
additional affidavit.
You have filed.
File additional affidavit.
When did you file this?
I'm sorry, my lord, this morning only I
This
filed.
morning, so let it be made a part of the record first.
So, my lord, therefore, if nobody is there, my lord, as per the information, my lord, I went to the office of the, my lord, this secretary planning and as well as principal secretary. Nobody has been specifically posted, my lord. As per the information, this secretary commissioner, of course, she has not been, my lord, endorsed all this.
Okay, then what you can do is, if he's in charge, then you can say in charge. Okay, so finance secretary so-and-so is.
Now
the
she's
finance-
looking
is the
after entire
finance
thing, my lord.
department- Is the finance department also a necessary party here?
My lord.
Is the finance department a necessary
Yes.
party? Okay, the name of the person, finance department, okay. Principal, okay.
My lord,
Then the other person will be Mr. So-and-so, holding charge of this department, in charge.
my lord, difficulty is when nobody has been posted therein. My
So
lord,
in charge, the in charge
my lord, in
secretary.
charge, as per the information, my lord, therefore, respondent number 3 has been impleaded, my lord. And now respondent number 3 is saying that I am the commissioner who is looking after the, my lord, the other, my lord, department also, my lord. That is the whole problem, my lord. Now the information, as per the information, nobody has been particularly posted. Respondent number 3 is looking after the entire thing, my lord.
Yes, are you looking after, or you have to find out? Because see, in the contempt, they don't want to be implicated unless
So
it is
therefore, my
shown
lord,
that their responsibility is
one
there.
person must be there, my lord. One officer must be there who is holding the post of the, my lord, the planning and investment as well as the finance, my lord.
So someone has to be there.
My lord.
Now
But-
he's saying that I am only the secretary finance.
Commissioner of
I-
Finance.
So it
Commissioner
can be the
Finance.
commissioner also. I'm only the commissioner finance. Okay. So now you can,
My lord,
and if you feel that he's the same person, the commissioner of finance is also in charge of the other department, then you will have to make it so and so in charge, secretary in charge of this department. So that responsibility, they have to take that responsibility. Same person, then you'll name him again, saying he's also
Holding the
secretary
post of
in
finance.
charge, so and so. Okay, then
Capacity would be different.
then he will have to address the issue being in charge of that department. Okay, as the secretary, he will, whatever reply he has to make on the part of the finance department, he will give his reply. Then as the in charge secretary of the whatever that planning department, investment, whatever, that's a new department you've never heard of,
Well,
he will give us. So he'll have to file
I'm-
two affidavits in his two separate capacities.
May I pray that one,
Uh.
my lord, the one aspect, my lord.
Uh-huh.
My lord, let the notice be issued to the London Chief Secretary, who is the holding, who has been
Okay,
allocated.
he's been made a party,
No, my lord.
then
That
you
is
have
the,
to implead him.
my lord, difficulty is, my lord, if nobody has been posted there, my lord, it has some, if
Then
allocation is done.
implead the chief secretary. If he's not impleaded,
My lord,
notice cannot.
the
be
difficulty is, my lord, as per the original direction, the Chief Secretary has not been made as a party, my lord.
Then, you see, so you can.
Then, my lord,
so
where
you
from
can,
I
you
have-
can do your homework, okay? This person who is secretary, commissioner, finance department, find out if he is in charge of this other department. If he's in charge, then you implead him in his capacity as being in charge of that department. Okay, not,
My lord.
because otherwise he'll not take the
My lord,
responsibility.
I myself asking the question myself, my lord. I am not, my lord, to whom to implement, even it is not clear, my lord.
Then
So
find
department
out,
is,
find
my
out,
lord,
find out.
we don't know, my lord, how this management is going on, my lord.
So find out, see, you're the petitioner.
Specific allegation, my lord, specific allocation is not done, my lord. That is the whole
But
problem.
someone will be in charge. So find out who is taking charge of that department.
My lord.
Someone has to be
My
in
lord, we
charge.
tried our best, my lord. There is no, my lord, no one has been allocated this fund, my lord.
Then no one will be, this is planning and investment, someone has to be in charge.
My lord.
If you feel that it is concerning
My lord, name must
financial
be,
matters.
name may be different, my lord. The persons who is holding presently holding the post of the secretary, planning and investment may be different, my lord. That is the only one aspect, my lord.
So find out, okay, and then you, after that, you can file an impleadment
And
application.
the other respondent number 3 is so miser, my lord. Even she don't want to disclose the name of the persons who is holding the post of. That is one aspect, my lord.
So I'm
See,
not
he's
able to
principal
understand.
Secretary, so he's a principal secretary, come secretary finance.
Yes,
Find out the correct designation, the correct post has to be given, okay? So anyways, so respondent number 3 says he's only finance department.
Finance.
My lord,
Now, finance department a necessary party is in the instant contempt?
no, my lord, direction, if lordship peruse the, my lord, direction given by this honorable court
Uh-huh.
at page number, my lord. Page number, my lord, 9 is start from, my lord. Page number,
9.
annexure 1,
Okay,
page number 9.
okay. The operative part?
Yes, yes. Earlier, my lord, the secretary finance, it is not necessary that secretary finance, secretary, my lord, principal secretary, government partnership parties.
Respondents number 2 and 3 to
3.
make allocation. So respondent number 2 and 3 are who in the writ petition? 2 and 3 is principal secretary,
And
Department
secretary-
of Finance, Planning and Investment.
Investment, my lord. Now, if even if person is not holding the post of planning as well, my lord, but of course, he is holding the post of planning and investment along with the finance, my lord. If not along with the finance, my lord, the finance word can be strike off, my lord. But if amount
Okay,
is to,
so you find out the name of the person
who is
who is
holding
holding the post of
planning and
planning
investment. My lord.
Okay, implead him. Okay, because if.
So therefore, my lord, that direct, my lord, the assistant can be rendered by the respondent number 2, since he is one of the respondent number 3, my lord. Sorry, respondent number 3, my lord.
It's fine, fine. Anyway, heard Mr. M. Kato, learned counsel for the petitioner, who submits that in view of the objection, affidavit in opposition filed by respondent number 3, who has denied being the secretary in charge of planning and investment department, he may be given time to file an impleadment application impleading the secretary, planning and investment department.
Well,
We find out. Okay. Or the secretary in charge of the said department. In view of the above, list after 2 weeks. Meanwhile,
my lord, 1 week, a week time may be
additional
given, my lord.
affidavit filed by the learned counsel for the petitioner is to be made a part of the record. Because it's not been received by the registry, nothing, you've just produced it like that, isn't
My lord,
it?
that is,
It's to be made a part of the record through the registry. Yes.
my lord, a
List.
week time may be given, my lord. I'll try to find out.
Okay, list after 1 week. Yes.
Lordship, in this item, Lordship, may I please, your Lordship, in this item, I am appearing for respondent number 2. Today, I have filed the wakalatnama. Just I require some time for filing my affidavit, Lordship.
Okay. Mr. M. Kato, learned counsel for the petitioner is present, while Mr.
S.S. Roy.
S.S.
Yes,
Roy,
For
learned counsel appearing number 2.
2.
Okay. And has prayed for time to file his counter affidavit. Yes, then anyone else? 2 is there, 1?
I have already filed.
My lord, step was taken long months back, but today they are coming after filing of the additional affidavit saying that, my lord, the service has been caused up to the respondent number 3, my lord. Now of late, my lord, the other party is coming. So therefore, my lord, at this stage, my lord,
Who let them found their counter?
Lordship.
my lord,
Respondent number 2 represented, they will find their counter.
my lord.
Okay. And then.
On my part, I have already filed.
My lord, what I'm my lord, submitting is a short, my lord, that may be
Okay,
given.
okay.
It's because the service has been caused upon to him long days back, my lord.
Okay, counter affidavit, list after 2 weeks.
Lordship.
Okay.
Let
Yes,
it
so file your counter by that time.
Lordship, let it be fixed. The date may be fixed, Lordship, because I am appearing online, Lordship, 9.
Okay.
19th.
On 9th.
19th.
19th. Okay, on, is it 2 weeks?
Lordship, it will be 3 weeks, Lordship.
On 11, my lord.
Try and make it 11.
Lordship, I will be not there, my lord. Lordship, let it.
Okay, then list after 3 weeks on 19th, 11, so and so. Okay,
Lordship.
the learned counsel for the respondent number 2 is to file their counter affidavit positively before the said date of listing. Yes.
Lordship. Oblige, Lordship.
Number 16 and 17.
Yes, this is I.
My lord, I am for the applicant here. Here I am praying for implead me as a respondent number, private respondent number 5 in instant rate petition for 450.
Okay, you want to be impleaded.
My lord.
We'll have to issue notice.
My lord.
Okay, isn't it?
Yeah, let the notice be issued.
Yes.
My lord, before issuing notice, my lord, this applicant has to satisfy, my lord, whether he is a necessary party, my lord. Because,
So
my
you
lord,
file your objection in the next date if it's not necessary, isn't it? He's made a prayer in the IA.
my lord,
So then you receive a copy, and then if you're going to object to him, then let it be objected. Whether he's a necessary party or not, we'll see. After you file your objection, if it's not necessary.
Otherwise, I have already explained the reason that the
He's,
Board of
anyways,
the Contention is.
then you also do your homework, isn't it?
Absolutely.
Yes.
I'm ready.
Heard Mr. So,
Imoli.
learned counsel for the applicant who has prayed that he may be allowed to be impleaded as respondent number 5 in WPC number 45 within brackets AP/2024. The learned counsel submits that he is a necessary party to the said WPC 450/2024. Oh, why? Why are you a necessary party?
My lord, on the ground that the land in dispute between the private respondent number 4 and petitioner, I have also the land in the same place. They over the land, over my land, the dispute is going on between the petitioner and the private respondent number 4. So I am deserved to be heard and here.
So you're the owner of the land which is disputed in this.
My lord, the issue before this honorable court is different, my lord. It's very different, my lord.
Okay.
No,
we'll see.
I got that.
Okay. Submitting that he is the owner of the landed property which is involved in the said writ petition. Okay, we'll make it that. Okay. Issue notice to the respondents
Opposite party number 5,
/ opposite party, Mr.
number 4, 4 only. 4 is required. Step is need to be taken to the respondent number 4.
Okay.
There is
So and so accepts notice
opposite
on behalf of
5 is
Respondent number 5.
respondent number 5.
opposite number 5.
And
Your
Miss
Lordship, I'm appearing for 1, 2 and 3.
and Miss so government advocate accepts notice on behalf of respondents number 1, 2, and 3. Requisite copies of the IA to be duly furnished to the learned counsels for the respondents. Any other person to be issued?
Respondent number 4,
Okay,
opposite party number 4.
private
Yes, private.
to registered posts.
Yes, to register.
Notice be issued to the private respondent number 4 through registered post with AD within 3 days, returnable by 3 weeks. Okay, as well as through usual process, list after 3 weeks.
My lord, I need some more time to file affidavits. So my friend will say then there should be a interim order. But if really he project cross his road, definitely he will never allow, they will never allow the executing firm to execute. So there is nothing to be worried.
Okay, so here it says that dusty service upon respondent number 5 is also required.
Complete.
Complete? Okay,
My lord,
yes.
just if I'm given 5 minutes indulgence.
No,
What?
I am seeking time.
He wants some
No need to waste time.
yes.
Yes.
Still.
What?
Still.
So we will give him time to find his
Yes.
counter.
No,
Okay.
but that's why
After 3 weeks.
I'm seeking some small relief in this because there's Vibrant Village program. My lord was the first to give an interim order in this series of projects, my lord. And that was subsequently followed and that, no, my lord, not in this, another read.
Okay, not
So,
so
my lord,
yet,
then what had happened was, my lord has given a option first for disposal of the representation by the government. And then thereafter, this Justice Ete also has rendered one more judgment. My lord, it is like this. The fact, my lord, the
this is a scheme.
yes, but the fact is like this. There is one particular clause called 6.12 in the guidelines of the Vibrant Village program, which they are following under PMGSY guidelines. Now there, what the requirement is, you must obtain a consent from the villagers before preparing the DPR also. Now here, the executive engineer who has plotted the NIT has categorically made a statement here. One document here has given a certificate saying that the consent was not taken. One. Number two, the Gangburas, my lord, the GB. Now, my lord, after coming into force of the Arunachal Pradesh Civil Code Act, in terms of section 2, the definition clause, the village Gangburas are the village authorities, and they are the lowest category of judicial officers in the indigenous form in the state. My lord. Now, a Gangbura is explicitly not empowered to execute memorandum of understanding to part with the land or to donate the land to the department to construct the road, my lord. So that is prophesy an illegality, my lord. Now, my lord, today, because my brother's favorite judgment is NG product, my lord. Now after this NG product, my lord, there are judgments in 2024 that I'll not disclose it because in the
Well,
final
exactly,
argument
there
we
is
will declare.
disputed.
So, my lord,
This is at a very initial stage.
I'm making
Uh-huh.
a small prayer today.
Uh,
Since there is a prima facie illegality in the actions of the state respondent in plotting the tender, my lord will make an observation. Entire tender process will be subject to the outcome of the writ proceedings and appropriate fixed date for admission hearing. On which date, with or without affidavit, the matter should be heard. Whereas he would always, as a state council member, my brother is the most fairest man in the court, my lord. With all honesty and integrity, he would always make the submission because, again, he is also handicapped by the government, my lord, at the top. And my lord might have noticed one more thing. In Arunachal, my lord, every tender, every project is put under challenge before this honorable court. Then my lord can understand the gravity. Definitely, there must have been some wrong actions.
Oh, so this is for the construction of the road
Correct.
in some village, is it?
No, construction is now going on.
It's going on.
Yes, now these people, they come up with a petition that this
No.
road is going to go passing through their private land.
the village,
So they have acquisition as a donation has been
So they
taken
want
with
compensation, is it?
no compensation.
They want compensation. Is that why the writ petition has been?
My lord, simple thing is that they are also interested party. So this party, they did not get a tender, so now they are creating
No,
issues.
exactly.
These are the
So they
real
are saying
fact.
that they should be also
No.
reply to the tender, giving the chance or what?
No,
What is the writ petition about?
My lord, even in the guideline itself, it has
Okay.
provided.
We'll file our
Time of
affidavit.
framing, at the time of
Giving all the-
DPR, my lord, at the time of framing DPR, fundamentally they should take consent. Here, almost 9 of the.
Okay, so because your consent was not taken,
Not
your this thing, you filed the
I'll
writ
demonstrate
petition. Is
one-
that the thing?
my lord,
huh?
I can demonstrate one particular document.
That is why I'm
Okay,
submitting.
so let them reply to your this
Yes,
thing.
if
isn't it?
road pass through their land, definitively they will not allow.
My lord,
I'm submitting here today.
my lord, kindly come
So
to
if
page
road
50.
construction without any problem, that means the road does not pass through their
My
land.
lord,
Anyways,
my lord,
let's see.
kindly
page
come to page
54.
54.
What does page 54 say, huh?
The executive engineer who has plotted the standard.
Vibrant Village
Yes,
Program, yes.
this is to certify that I am the executive engineer, DPIU, RWD Chain Tajo, a notice for inviting tender number so and so, that so and so was called from my end for construction of roads under Vibrant Village Program, BVP, in different villages of Chain Tajo constituency. As per minutes of meeting for opening of technical bid constituted under the chairmanship so and so, I was made one of the member of the board, but as per order dated 37/24, number so and so dated issued by SERWD Circle Rupa, I was excluded from the board of member without my knowledge under the capacity of the member secretary of the project. I was present in the station right from the beginning of tendering process till uploading of technical bids. Furthermore, digital signature for opening of digital portal was used for opening of technical bid without my knowledge and my consent. Moreover, the technical bid tender result was uploaded in my apps. Well, the prima facie illegality is there, my lord. This is the official documents, my lord. Once it has come in the form of official record, and my lord, kindly see the Gangura who has executed that. Where is that? One more document, my lord. Why I am making that prayer? Subject shall be subject to the outcome of writ petition. Because I am not praying. We are not against the
Okay,
development.
subject to the outcome of the writ petition, we can add that, okay. But Mr. T.T. Taro, learned counsel for the petitioner, along with Mr. So-and-so, learned, you're for the?
RWD.
Fix that.
1 to 4.
Okay, learned counsel for respondent number.
I am for
four.
respondent number 5 here.
and Mr. So-and-so, learned
Private.
counsel for respondent
number five.
number 5. The learned counsel for respondent number 1 to 4. He's the what? Additional agent? AG, government advocate. 1 to 4. Standing counsel. For which department? You're the standing counsel for?
RWD.
Okay, RD department has prayed for further time to file the counter affidavit. Meanwhile, as prayed for by the, as submitted by the learned counsel for the petitioner, the outcome of the incident, what is this?
The
NIT.
the entire NIT process shall be subject
Okay,
to
the
outcome of this.
The entire NIT process will be subjected to the outcome of the incident with petition.
We have consensus on 19, list this matter on 19 November.
List the matter as prayed for on 19/11/20.
Great for them.
Yes.
May I please, Your Lordship? Your Lordship, I'm appearing for respondent number 1 and 4, Your Lordship. I beg to pray for some more time, Your Lordship. We need to file our counter affidavit. Your Lordship.
Okay. Will give them time?
In this case, my lord, the matter is basically for the acquisition of lane for the road construction. What happened was that before the notification for the acquisition, Deputy Commissioner has issued a notice saying that public should stop constructing any assets in the roadsides. So that matter was challenged before your honorable court. And then the honorable court has held that the notification which the Deputy Commissioner has relied and rejected their compensation. Basically, they have prepared the 3 lists. One list was for the eligible for the compensation. The second, third list was rejection list on the ground that notice was issued prior to the land acquisition notification. And the same was challenged by the other landowners, my lord. And then this matter was heard by the honorable court, and then it has held that on the basis of rejection on the basis of notification, notice which is issued prior to notification is not sustainable, my lord. It is held by the 2 coordinated bench, my lord.
So here, in the last court order, it is said that the learned government advocate shall send a downloaded copy of this order to the Deputy Commissioner and to do the needful, isn't it? So who is representing the Deputy Commissioner?
Your Lordship, in this case, we are representing Your Lordship. Yes.
Otherwise, my prayer will be that it can be disposed on the COVA case, my lord. I will just go to 2 judgments. There is paragraph.
So give them a chance, give them a chance, let them get instructions, isn't it? We'll fix a short date. Heard Mr. S. Mao, learned counsel for the petitioner, while Miss so-and-so, learned government advocate, has prayed for time to get instructions, is
Yes,
it? And file their counter affidavit?
But
Not required.
Yes, Your Lordship.
To get instructions in terms of this court's order dated 19/09/2024. Okay. Then, what about you?
My lord, I am for 1 and 2, madam.
Any submission to make?
No, my lord.
The presence of Mr. So-and-so, learned government advocate for respondent number 1 and 2.
Yes, ma'am.
Is noted, yes.
My lord, that may be fixed, my lord, because matter related to compensation.
After 2 weeks,
2 weeks.
on?
2 weeks, Your Lordship.
On, my lord.
They want a date list after 2 weeks on?
Your Lordship, 3 weeks, Your Lordship, at least.
They have to file only what your lordship order was only just to file.
Your Lordship, this
Have to get instructions from the Deputy Commissioner.
Shiomi district is quite far from here.
Pardon?
Shiomi district is quite
The
far.
matter was before the vacation bench. Almost they have taken one month, my lord.
Give them 3 weeks, okay, list after 3 weeks.
Then, my lord, date may be fixed, my lord.
On? Give me a date, 3 weeks.
Yep.
12/11.
12/11.
Okay, 2024, yes.
My lord,
Yeah.
if they don't file, then, my lord, our prayer will be that being a COVA case, matter should be disposed of, my lord. That is our prayer, my lord.
We'll let them first
All
file
right.
their this thing, then we'll see.
Obliged.
Obliged.
Lordship, in this case, I am appearing for respondent number 1 and 2. My lord, kindly see the last order, Lordship. The last order dated 24/9, Lordship, 24/9/23. Last paragraph, Lordship.
Yes, so any steps taken?
Lordship, we have disposed of his application on 39/24 and emailed him, Lordship. Now the matter become infructuous, Lordship, because third party has been selected, Lordship, in the draw of lots, Lordship. Either he has to implead the newly
To dispose the representation submitted by the petitioner. So you have disposed the
Yes,
representation?
Yes, Your Lordship.
How was it disposed?
It was disposed of rejecting his prayer, Lordship. Because his didn't come under the his land was
Okay, so your submission is that in terms of this court's order 2409/2024, his
Lordship.
representation has been disposed of and
Yes,
rejected, isn't
yes,
it? Yes.
yes.
So now what happens?
Since they have already selected a new another guy, now we have to implead him. So
Okay.
we need some time to
Yes.
implead him.
Fine, Mr. Etaka, is it?
Tigyatso.
Tegyeso, learned counsel for the petitioner is present. Along with Mr. S.S. Roy, learned counsel for respondent number
1 and 2, Lordship.
1 and 2, who appear true, we see. The learned counsel for respondent number 1 and 2 submits that in terms of this court's order dated 2409/2024, the representation submitted by the petitioner dated 20/09/2024 has been considered and disposed of, wherein the representation made by the petitioner has been rejected. In view of the above steps taken, the learned counsel for the petitioner has prayed that he may be allowed to file an impleadment application, impleading the concerned person, which resulted on the disposal of his application dated 20/09/2024.
Lordship, may I please, Lordship, is petition may be dismissed, my lord, because fresh cause of action has arisen, Lordship. He has to challenge that order.
No, see, when he files the impleadment application, then we'll issue notice and then you can mention
Whether the cause of action is selected.
whether the cause of action in this writ petition will still survive.
Lordship, let the date may be fixed, Lordship, let it
Okay,
be.
yes. In view of the above, list on
1911.
19/11/2020. Yes.
My friend will serve a copy to my email, Lordship.
Okay.
Lordship.
Then once he does, he'll do it.
Oblige.
Oblige, your Lordship.
Yes.
My lord, I apologize for the intrusion, my lord. My lord, in item number 5, when Lordship
one is
considers passing the order, would Lordship also consider giving them a time-bound period within which they should give effect to that? Because otherwise, they'll keep it pending for long. 3 months or so, my lord, if possible.
Yes,
Otherwise, they'll still keep it pending.
Then when to file a contempt, that's your right.
My lord, for that the time period.
Okay.
So 3 months or so, my lord. Deeply obliged.
Such a year.
Hmm.
For disposal of the matter and subject to convenience of the part of the other learned friends. And if at all, my lord, I'm ready to, my lord, argue for the, my lord, make submission for the disposal of the matter, my lord. Subject to convenience on the part.
We're ready.
Matter's been listed for hearing today.
My-
Is it? What's the matter about?
My
Okay.
lord, this is cancellation of the LPC issued in my favor by the additional deputy commissioner in most arbitrary and illegal manner.
Okay, yeah. LPC was cancelled.
Cancelled.
Hmm.
And there is no provision as such under the statutory provisions that cancellation can be done by the additional deputy commissioner. Ma'am. Of course,
Okay.
my lord, the allotment. Had it been the case, then my lord, if the allotment is LPCs is to be cancelled by way of my lord, taking recourse in judicial manner, the cancellation can be. But my lord, the additional deputy commissioner, who himself issued the LPC, see himself by being other incumbent, my lord. The predecessors, as a predecessor, he ought not to have taken that recourse, madam.
Okay, okay, let's say why was it cancelled?
Cancellation,
What,
madam.
it was in reserve forest? area
One
or
officer,
something?
madam, one officer who is holding the post of the additional deputy commissioner at that relevant point of time issued the LPC in favor of me after following the due procedure of law, and that cannot be directly cancelled by the another officer who has come and joined in the same post after transfer of the earlier additional deputy commissioner. So that is one of the, my lord, the ground also, my lord, I've taken.
Hmm.
My lord, brief fact of the case is the petitioner and the respondent number 5, private respondent number 5, where the husband and wife since 2002, 2010, madam.
2 to 10.
2 to 10.
8 years. They were married for 8 years. is
Yes,
it?
madam. Married.
Hmm.
And during the, madam, they stay together as husband and wife. Madam, they acquire so many properties.
Petitioner is the husband.
My lord.
Oh.
Respondent number 5 is the
Wife.
was the wife. And during their stay together as a husband and wife, so many properties, including immovable and movable properties, were acquired. And that, my lord, immovable property, which I have specifically mentioned in my petition also, as well as the reply, that has been taken away by her only, respondent number 5, without giving any single, my lord, the properties to the petitioner.
Okay, property is taken by the wife.
Yes, madam. Everything, even vehicle, movable properties, the immovable properties, everything, man. And the petitioner has not taken any, my lord, the properties which has been acquired during the lifetime of, my lord, their stay together as husband and wife, man.
So, just out of curiosity, under what law were they divorced? Customary
My lord,
law,
just
something
only
like that?
divorce. We tried the both
Mutual consent.
consent, not consent, my lord, without just that is left away, left and my lord, separated each other without any there being any conclusion, my lord. I have also taken that ground also.
Okay.
There was no any, my lord, the decision. There was no any, my lord, any kind of, my lord, any form of, my lord, settlement made between the private respondent number 5 and the petitioner. My lord, in fact, I have enclosed the copy of the, my lord, the petition before the, my lord, arbitrator. The arbitrator for holding arbitration, even that was tried, but she failed, my lord. And that way, my no settlement, my lord, as of now, just only separated since 2010, my lord.
Okay, no, since they were husband and wife, okay, but the issue is not regarding
Not
property.
regarding that. Now, my lord, during
Because
their,
I was thinking
yes,
they were husband and wife, if it's a dispute regarding property, can't it be settled in local adalat?
my lord, during their stay together as husband and wife, one of the, my lord, the plot of land was acquired in her name, my lord.
Mm-hmm.
In her name, my lord. And in the year 2000, my lord, 6,
Hmm.
in the year 2006, and one that property was acquired in
The
her name.
present disputed property.
Yes, my lord.
Okay.
That was a small piece of land, my lord.
Hmm.
And that property was acquired in the year 2006, my lord. I'm sorry, my lord, 2006. And separated in the year 2011, 10, my lord. And after, my lord, that even before the separation, my lord, the petitioner mother is staying there at the place where, my lord, the plot was purchased in her name, my lord. And amount was paid by me, my lord. It was, of course,
Okay, you bought it.
yes,
Okay.
my lord.
Ah.
And thereby, my lord, my family members, my lord, residing there, my lord, especially my mother, my lord, age old mother is still presently staying there, my lord, by cultivating, my lord, the agriculture, and my lord planted many, my lord, fruits bearing trees, and bamboo, my lord, bamboo group also, my lord, constructed fencing. Lordship will
Okay,
be,
so your mother and father are still staying there.
my lord,
as
my
of
especially
today.
mother, my lord, age old mother is staying at the same place where, my lord, it was purchased, the present dispute is
Okay.
located.
So it is cancelled and mutated in the name of respondent number 5. No.
Yeah, no. My lord, thereafter, my lord, in the year
So it
2000,
belongs to the government after it's cancelled or what?
it was private land, my lord, purchased by me, my lord,
Hmm.
in her name, my lord. Thereafter, my lord, separated in the year 2010, my lord.
Hmm.
After, my lord, the separation, my lord, of course, of late, my lord, I applied for the issue of the LPC, my lord, land possession certificate by following all due procedure of law, duly prescribed in the, my lord, the format prescribed by the state government, my lord. There is a permit. I have enclosed the copy of them. If lordship, I'll come to that part, my lord. Just I'm briefing the, my lord, the brief facts of the case, my lord. And applied for the, my lord, the my lord, issue of the LPC only in the year 2018, my lord. Land was purchased in the year 2002 and separated in the year 2010. And I applied for the LPC against my land in the year 2018, my lord. Thereafter, my lord, the LPC was issued in my favor in the year 2018. And till 2018 to, my lord, the 2023, my lord, 2023.
Yes.
For this long 5 years, there was no any claims and objection, my lord. In the year 2000, my lord, 23, my lord, private respondent number 5, my ex-wife, my lord, made the complaint before the additional deputy commissioner, my lord. And in the additional deputy commissioner, my lord, she had made, my lord, so many allegations against me, against the officials of the, my lord, additional deputy commissioner. If, my lord, perused, the nature of the allegation is very serious, my lord. But without going into that allegation, who has done, how it has been done, my lord, without examining the, my lord, the allegations and the, my lord, the claims of the, my lord, the respondent number 5, the additional deputy commissioner issued notice, and, my lord, wherein I have filed my detailed reply, my lord, written statement before the additional deputy commissioner, my lord. And, my lord, after filing of the complaint and filing of the reply by the, my lord, the petitioner, the additional deputy commissioner finally, my lord, decided the issue by the order dated, my lord, 28 September 2023, my lord, which I have impugned as annexure 1 in the writ petition, my lord.
Okay.
And by, my lord, that impugn order, my lord, specifically ground of rejection is not serving notice upon to the my ex-wife, who was, my lord, claimed to be the owner of the land which was purchased by me in her name during our stay together as a husband and wife. But my lord, my submission is there is no provision as such for serving notice upon to the wife, my lord. Now, the additional deputy commissioner has arrived at findings specifically that no notice or no opportunity has been given to the wife, my lord. Now, my lord, interestingly, my lord, in our traditional and customary system, my lord, once it is separated, once it is divorced, the property which has been acquired from my own family members, my lord, that has to be taken by the husband only, my lord, not by the. And those ornaments or other things, if it is exchanged during the, my lord, the marriage ceremony to the husband from the girl side, my lord, then that will be taken away by the girl side, my lord. The same way,
Where's your customary law?
Madam,
That's a customary law or it's not written?
it is practice, madam.
Okay, it's not
It is
in
practice.
written form.
There is a practice, madam. So the land which was originally purchased, was originally belongs to my own cousin brother, man. It is owned, man, the family land, man. Only for settlements of the husband and the petitioner and the respondent number 5. This plot of land has been, given. That was very small plot of land at the cost of in consideration of RS 2 lakhs only, madam. It was only for the purpose of the residential area, madam. But the area which I have obtained subsequently from my cousin brother is huge area, madam. And now the respondent number 5 is claiming that entire area to be her land, madam. It was purchased in her name, madam. But exactly it is not the correct, madam, the contentions there. The area which has been purchased in her name was only the small area, not the whole area. Now she is claiming that entire area has been purchased by me. That cannot be, the obtained LPC by the petitioner, and the obtainings of the petition, the LPC by him alone is illegal, That was the whole contention. So now the decision.
Let's see.
That is the whole issue, Now, if Lordship peruse I'll skip first impugn order annexure 1. The area where I'm my mother, one memory.
Yes.
Memory is also constructed there. Memory of my sons, brother's sons,
Okay, this is annexure 2.
Annexure 2, page number 25, my lord. She's, past is my mother, my age old mother, and the
Okay, so
cultivation
this lady is the wife or the mother?
my mother, petitioner
Okay.
mother. And next page number 26, my lord, I have developed the cultivated entire area by possessing this piece of land, my lord. And my lord, Lordship may kindly come to page number 27. This is the LPC, my lord, format, my lord. This is the prescribed format, my lord. We have to fill up. This is still prevailing, my lord. The government has not changed this format. This is the the applications to be filled up by the applicants who desires to obtain LPC. This is application format. And I have filled up these applications. I have given entire thing. Area is also given. Northeast boundary. This description of land is also given. Then next page. This is also one of the format, page number 28. Notice. How notice has to be served, and that notice has to be served by the officials of the office where the LPC application is filed, Format of notice for inspections of land,
So notice is served to who? Respondent number 5.
Not respondent number 5.
Who is this?
There is no the provision. This has to be may kindly whereas if I read whereas Srimati so petitioner, me so and so has applied for issue of the possession certificate as described below. This is the described description. And whereas the EAC Balijan designations of the administration authority will visit the land on so and so date at so and so hours, along with the survey teams to inspect as to ascertain the actual owner of the land. Now, therefore, the following persons are hereby directed to remains on the above mentions place on the date and time specified above and which and whose presence authority will arrange or survey and inspected the land. Man. They are the names, my lord, who are required to be present on the date of inspection. And this has been issued by the ADC oblique EAC come CO, my lord. And again, another notification, madam, not another notice, madam. Written notice for written objection, madam. There is a permit for the written objection, madam. This is the again, madam, notification, madam, detail permit prescribed by the office, madam. There and I'm getting, madam. And therefore, a notice is hereby issued for the general information of the publics of the locality, and in case of any persons, has any objection to the issue of the land possession certificate in favor of city so and so, in respect of the land described above, she submit objections in writings to the undersigned within 15 days from the date of issue of this notice. And if no written objection is received within the above specified period, it will be deemed that city so and so is sole owner of the land described above, madam. This is the madam, the permit, madam. And no objections.
So where's this notice made? Just a notice, but it's issued to whom? Okay.
Madam,
people
general,
of this board.
it is in the notice board, madam. To be in the notice, all concerned by name, madam.
So who are the concerned?
Concerned, my lord, we have given the serial number 1, serial number 2, and serial number 3, madam.
Okay, these are in the presence of these people, isn't
Yes,
it?
madam. And even it was hanging in the notice board, madam. And no objection certificate. There was no any objection certificate, my lord. That has been duly certified by the head GB, my lord. More interestingly, my lord, the head GB at the time of my lord hearing by the additional deputy commissioner, my lord, he stated before the additional deputy commissioner, no, the objection, no objection has been obtained under the impressions that they are still living together. Therefore, this no objection certificate has been issued in favor of me, madam. But
DB has signed. No,
My lord.
GB has signed
GB
a no
has said.
objection.
And this is another second, Annexure 4 is the another the application, basically for 2 LPC, same format, same date. After following the current formalities and entire things, the London Additional Deputy Commissioner issued LPC certificate in my favor. It is Annexure 5, page number 36, 2 LPC certificate, land possession certificate. And Annexure 6 is also page number 37. One is one area, area is very much important, The first LPC 1 is Annexure 5, page number 36, 47,961, And another one is 49,066, This is the LPC issue. And may kindly know that it was issued in the on 21st July 2018, and separated in the year 2010. And this LPC was issued in the year 2018, Now, the complaint has been, after issuance of this LPC, for complaint has been lodged by the private respondent number 5 only on 8 August 2023, after 5 years. May kindly peruse the page number 38, Annexure 7, This is the complaint, addressed to the Additional Deputy Commissioner, Balizan, so and so. The reference number so and so given, Subject, complaint against Siri so and so, former husband for the fraudulent and dishonestly obtaining the land possession certificate in respect of a plot of land owned by the undersigned situated at Holongi village in nexus with the issuing authorities, and immediate cancellations of the said LPC along with the strict action against the culprit, Now, this is the contentions, I'll skip this part. But what the allegation is, I have pointed out, this is a serious allegation, page number 40, para 7, Of late, I learned of the news that Sri so and so, my name, petitioner, fraudulently obtained the LPC certificate of my side 2 plots of land by misleading the people and bribing as well, conspiring with the government officials of the Office of the Additional Deputy Commissioner, madam. As I pointed out, this is a serious allegation, madam. Balijan, as well as the officials of the Land Management Department, madam. This is the matter contention of the. So this the made wild allegation, but then no inquiry to that effect, madam. That has not been ascertained, madam. And page number, my lord, 42, my lord, again, para 17, my lord. The actions of the extra assistant commissioner Sri Nabam Taje clearly suggest that there is a conspiracy between him and Sri Kabakba, and that they work in connivance with in pursuance of their stratagem. The employing illegal methods of fraudulently and deceptively issuing LPC so and so, dated so and so, located at so and so in favor of so and so man. This is also a serious allegation. As I pointed out, there is no. Now, in complaint, the conduct and other it is of course not not fair to make summation. However, it is not in a place to escape the conduct of the respondent number 5. Kindly fair use the page number 44. This has been drafted by her and it was signed before the signed at Guwahati, not here.
Okay, what is this promise?
This promise, just to ascertain the conduct of the respondent number 5. This was written by type copy. It was done by him. Just I might put my signature only.
Yes.
I see so and so, so and so, I'll skip. I'm marrying to so and so, so and so, so and so of Sambang circle of my own wishes. I do here promise that in my future I never deceives to her and I'll not give physical and mentally torture. Our relationship was starting from 27 October 2000 and she is only my wife till my day. I never complain about her character. In my future, I never look or think for second marriage. And I'll keep her even she does not give birth. And in case in my future, if I look objecting for second marriage, she may kill me either by
So what's the use of this document? This is in the beginning of their marriage, isn't it?
Yes, my lord.
So leave it. What's this?
Now, my lord, what it my lord, it reflects that there was a misunderstandings between the malad. So therefore, this has been of late, malad. This agreement has been done in the only year 2001, malad.
During the subsistence.
During their stay together in husband. Now, malad, what it they say that malad, this kind
It's
of malad.
okay, so that he can marry her. He has made this.
Yes, malad. Now, malad, the piece of malad, the money receipt. There was no malad agreement. There was nothing. Malad, as a token of love, as I pointed out, since we were the husband and wife, my cousin brother just in token of love, this piece of plot of land was given in consideration of just arrest 2 legs, malad. Not for the entire area, malad. This is only piece of land, malad. Admittedly, malad.
Okay, where's that shown?
Malad, page number, malad, for original is page number 45 and type copy is page number 46, malad. There is nothing, malad, only this money receipt, malad. And it has been also received from the malad.
So the plot of land is not described here.
Malad, nothing. There is no
Only-
agreement as such also, malad. Basing on these documents, time and again they are claiming the land has been purchased by me. So therefore, you cannot obtain LPC which the land against the land which has been purchased by her, malad. That was the whole contention, malad. But my contention, my submission is, malad, that of admittedly, a small piece of land was
You're
purchased.
the one who purchased it.
Yes,
Oh.
a small piece of land was purchased in her name as a token of love in consideration of RS 2 legs just for the residential purpose, my lord.
Hmm.
And there was nothing, my lord, no agreement, even nothing, my lord. Received, this is money received, my lord, and received by, my lord, the, my lord, wife of my cousin brother, my lord.
Okay, then previously you're saying it was in the name of your wife, respondent number 5.
5, my lord.
So was this thing LPC given for that?
My lord.
Did she have an LPC in her
No,
name?
no,
LPC.
no LPC, my lord.
Okay,
Nothing.
just a gift. Oh, okay.
My lord, it was merely purchased during our stay together as a husband and wife, my lord. So this
Okay,
is
so it was okay.
after
So
separation.
no LPC in her name.
Nothing, my lord. There is no agreement, HS. There was no, my lord, any other transaction, my lord. This is the only money received, basing on which she is claiming time and against that plot of land has been purchased by her during their stay together as husband and wife.
The nature of what you're saying, doesn't it require some evidence in the civil court or something, who purchased, who?
Exactly.
Instead of a writ petition.
She ought to have moved the honorable, my lord, the appropriate court, trial court, if she wanted to claim, my lord, against the land, my lord.
So no,
Now,
this case itself, now she's claiming she's respondent number 5, isn't it?
Yes, madam.
And she's saying that she's the one who purchased it.
Purchased.
While you're saying I'm the one who's purchased
Purchased,
it.
madam.
So
I'll come to that
then
part also, madam.
shouldn't we reduce evidence before the trial?
May I
court?
just intervene? I'm not stopping him at the same. I'll just intervene. My lord, after this property, because he admits that it is
He purchased
belongs to
it.
both of us.
Huh.
Okay. Then he surreptitiously managed to procure this LPC.
Hmm.
I filed when I came to know about it, I filed an RTI. From RTI, I came to know about all these things. All the records of the notices are, these were all furnished by me on it, got received from RTI. In any case, the ADC had admitted that I ought to have been heard, because it is admitted fact that the land belongs to me and or both to both of us. So, as your lordship had rightly pointed out, after cancellation, I have approached the civil court
Okay.
under the AP Civil Courts Act, the traditional customary court. The customary court has affirmed my ownership and declared the title in my favor. And
then he can appeal.
Yes, I have prepared appeal ballot. Same is
that
pending.
therefore, my lord,
You preferred an appeal.
Yes, madam.
Okay,
That is pending, madam.
it's pending. So then let that be decided.
Instead of going all out hog, since appeal is pending as he has claimed, and then already civil court has decided in my favor, title has already been decided.
No, my lord.
See,
Customary court, she
Customary
approached.
court say that it belongs to her.
Yes.
Is it? So if the customary court says that, then you have filed an appeal. It's
Yes.
pending before which court?
Correct, madam.
Pending before which court?
Learned Civil Judge Senior Division, madam.
If it's decided.
Subject matter is, madam.
Pending there.
Pending.
So if the learned senior civil judge
Madam.
decides that this is wrong and the land belongs to you,
Yes, madam.
then your cancellation order, the impugned order, that will also be set aside. How can we at this stage, when evidence has been taken, interfere with
My
that
lord,
finding?
my submission is this cancellation has been done past, madam. Basing on this cancellation, they approached to the village authority for, my lord, declarations of the title in their paper, my lord. And my lord, what happened in the village proceedings, my lord, we have submitted, we have given our statement, everything, my entire thing, my lord. But
So now
my lord,
it's
that has
appealed.
my lord, that has not been taken into consideration.
That's why you filed an
Yes.
appeal.
Appeal. Now, my lord, basing on this cancellation order, my lord, the village authority has passed an order in their favor. My lord, my contention is, my lord, the contentions before the additional deputy commissioner has not been taken into consideration. My lord, the entire, my lord, the grounds for cancellation is different aspect. Therefore, my lord, if in shortcut, my lord, if this cancellation order is, my lord, interfered with by this honorable court, my lord, since subject matter is already pending before, therefore, my lord, this the obviously, my lord, the rights and titles will be decided by the civil court, my lord. So therefore, my lord, submission is at this stage, my lord, of course, it will not bearing any impact on the, my lord, the proceedings of the trial court. But at this stage, this impugn order may be set aside and cancelled without having any bearing effect on the proceedings of the learned
It will have. So you can approach the senior civil judge also concerning this.
My lord, as I pointed out, if my lord, this had it been the, my lord,
No, then we'll have to look into everything. We'll be interfering
my
with
lord,
the.
my lord may kindly appreciate, had it been the case, then if this 2 LPC is not cancelled by the learned additional deputy commissioner, my lord, village authority could not have, my lord, interfere with. So therefore, basing on this LPC's cancellation, subsequently, there was nothing, my lord, during the pendency of this, my lord,
Okay, what we can do is at this stage, the operation of the cancellation order. It's Annexure 1.
Annexure 1, madam. That may be interfere with, of course, right and title will be decided by the, my lord, learned civil judge. That we don't have any objection, madam.
We'll
But,
just
my
say
lord,
that the operation of this order is stayed till the disposal of the whichever case before the senior civil judge.
or yes, my lord,
So
subject to
that-
the outcome of the, my lord, that.
We
my
can do that and dispose of this petition
Yes.
because see,
Yes, madam.
evidence is going to be taken to who bought it, who purchased it,
Exactly.
all that. Then interfering, it's not required.
Now, my lord, why I am, my lord, praying for the interference of this impugn order, my lord. If, my lord, once again, my lord, come to the impugn order at page number 23, my lord. The ground of the, my lord, the cancellation is completely far away from the contentions of the, my lord, the petitioner, my lord. Page number 23, para 9, my lord, I'm reading, my lord.
9, what does it say?
Madam, it says, this office has perused the official records of the process of issuance of the LPC and also compared with the annexures attached by the complainant, Srimati so-and-so, alias so-and-so. It is revealed during the statement that Srimati so-and-so was not aware of the entire process of the issuance of the LPCs, and non-issuance of notice to so-and-so, my lord, respondent number 5, suffers from irregularity and in violations of the principles of natural justice. And it may be noted that such that the LPC application form does not have any provisions in the format for notice to spouse for inspection and the written objection. Learned additional deputy commissioner is also of the findings that there is no provision HS in the prescribed format. Still then, my lord, it is, and also it is pertinent to mention that both had purchased the land in the year 2006, but the Sri so-and-so along God LPC issued for himself without any acknowledgements to Srimati so-and-so. Sri so-and-so had also mentions in the second hearing about non-interference from her on the said land, which also indicates that Srimati so-and-so, alias so-and-so, had the right over the land, man. In view of the above findings, both the LPC land possession certificate number so-and-so for the plot of land at Holongi so-and-so, and so for the land at so-and-so, issued in favor of Sri so-and-so, and so, are liable to be recalled and cancelled, madam.
So all this you can place it before the senior civil judge,
My
isn't
lord,
it?
that is already under consideration, madam.
So it's already under consideration.
So therefore, my lord,
So
my
why should we interfere at this stage?
my lord, this finding itself is wrong, my lord.
So if the matter is pending and brought before the notice of the senior civil judge, Let her decide on this also.
my lord, that aspect is something different, my lord. That is another thing, my lord.
What?
My
What
lord,
is before
my
the
lord, there is
senior
no
civil
provision
judge?
as such, my lord, for cancellation of the LPC issued by the same additional deputy commissioner, my lord.
So this same submission. you
My lord,
make it
unless it
before
is
this-
interfered by this honorable court,
Huh.
my lord, this will stand as it is, my lord. So this will be bearing, my lord, effects on the,
But the senior civil judge also has the power, isn't it? To say this, to look into this.
no, my lord, this has not been challenged before the, my lord, additional, my lord, before the civil proceedings, my lord. This is not challenged before that is subsequent, my lord, this application, this writ petition was filed much earlier before the initiations, before the village authorities, my lord. So therefore, my lord, my lord, simple summation is, if lordship interfere with this, my lord, with the directions to the learned additional deputy, my lord, my lord,
Senior civil
civil judge senior division,
Oh.
without having, my lord, the bearing, if, without bearing any effect on the basis of this, my lord, the judgment, my lord. So therefore, my lord, this is two aspect, my lord. That way, that is another proceedings, my lord, rights and title. And this is the
Before
cancellation of,
Senior civil judge, you are saying that you are the one who purchased the land and not the respondent number 5.
No,
Okay,
my
that evidence has been taken regarding that, isn't it?
my lord, may I
What is the case
my
before
lord,
the senior
in civil
judge?
judge, my lord, may I, as he has rightly pointed out,
Oh.
after cancellation of this, my lord, LPC, she went to the, my lord, customary court, village authority, and village authority, my lord, decided in her favor, my lord. Village authority, my lord. So after this cancellation, my lord, this was,
After this order, she went to the village district. So this order was there when you approached your senior civil
no,
judge?
my lord, that was never challenged before the, my lord. It was a completely different aspect, my lord. So therefore, this is another, my lord, the way of, my lord, the litigations, my lord, another way of, my lord, by challenging the, my lord, legality and validity of this impugn order, my lord. This is different proceedings, my lord. Of course, subject matter is same. My lord, present, my lord, the land, disputed land is same. But my lord, after cancellation, civil, my lord, village authority had interfered with the findings that land belongs to the respondent number 5, my lord. My submission is, had it been the case that if these two LPCs is not interfered with by the additional deputy commissioner by recall or cancellation, my lord, definitely.
You would still be in possession. It
No,
would be yours.
yes. Without challenging the, my lord, my lord, the LPCs, they approach to the additional deputy commissioner for
So
cancellation.
this evidence, you can place it before the. You can
So
place.
therefore, my lord,
So one of the grounds.
This is
for setting aside of the decision of the account bureau would be that this was never challenged.
This was not challenged before the, my lord, the village authority, my lord. This was not, my lord, that cannot be challenged before the, my lord, village authority, yes, because this has been all, cancellation has been done by the
So
additional
you
deputy
have
commissioner.
a good ground to appeal.
My lord, that appeal we have
No,
already
but
prepared.
they don't have to challenge this because this is in their favor.
Yes, my lord. Therefore, my lord, I am
so they
agreed by this order, my lord.
this.
My lord, I am agreed by this order. So therefore, my lord, my submission is, lordship may interfere with this subject matter of the, my lord, the ownership will be decided, of course, by the, my lord, the civil judge. Trial court, my lord. Unless if it is interfere with, my lord, the rights and title is, my lord, already is under the subject matter. So therefore, my lord, interference of this order will not bearing any effects on the proceedings of the, my lord, civil judge.
I don't know. Anyways, what do you have to say? No.
My lord, before I come to the textual aspects, my lord, I'm representing respondent number 5. My lord, his last submission, my lord, why it is not possible for this court is that this is a proceeding under judicial. Now there is a claim and counterclaim about the ownership who had purchased.
Who does it belong
So,
to?
this aspect, as a preliminary, this aspect of ownership, the dispute cannot be settled by writ court. This is for the lower court, civil court. Now, rightly or wrongly, the civil court has given a decision which he had challenged. Now, if your lordship permits his prayer of interfering with this impugned order of cancellation, recalling, it will have two effects. First thing is, it will amount to nullifying the proceeding, the decision-making process, and the decision itself of the lower court, which is already subject matter in the higher court. From that lower.
See, so a copy of the plaint or the appeal petition before the senior civil judge, okay, that also should be enclosed here so that we'll have to see, is it here?
Yes, no, my lord. No, my lord, exactly, my lord. That is,
So
that was the subsequent proceeding, my lord, as I pointed out.
What is the subject matter there? Whether they would also, it would affect the matter here. What is the issue that has to be decided there?
Now, my lord, may I
See,
just,
a copy of the, so you had approached the, what, senior
Village
civil judge
authority.
on appeal, isn't it? What is pending before the senior civil judge is the appeal.
appeal, my lord.
Appeal
Appeal
against-
against the order passed by the village authority, my lord.
So we'll have to see
Now,
whether the interest then would clash, because his only point is that notice need not be, you admit that notice not issued to the respondent number 5.
there is no
when-
provision as such.
So you're saying that notice is not required to be
Issued.
issued, isn't it?
Once it is
Well, their
separated-
ground was that notice has to be issued, is it?
Yes, ma'am.
Well, let me come back to the factual aspects as per his submissions, sequence wise.
My lord, I have not completed.
You have already prayed for.
You see, because
That was
in
the-
my mind, there's this thing, the matter is still pending, who's there, because then you came up with the issue that who bought the land. You said that it's a small plot of land, I bought the land, isn't it? At that time, now it's very big, all that needs evidence, nothing is there.
Yes.
If the LPC was previously in her name, okay, then we could look at the LPC and see what
Exactly,
the
my lord.
area, etc. Nothing is there.
Yes, my lord.
It's all in the air.
So therefore, my
Evidence
lord,
has to be taken.
my lord, therefore, evidence has to be taken.
Ah,
Everything has to be
it's-
decided by the appellate court, my lord, civil judge.
Ah.
My lord, what my contention is, my lord, why this, my lord, the LPC is cancelled? I'm, my lord, challenging the legality and validity of this very impugn order. My lord, there is no provision as such under which, my lord, the notice has to be served upon to my ex-wife, my lord. It was separated in the long year back 2010. I have applied in the year 2018, and a complaint was made after 5 years of issuance of the LPCs in my favor in the year 2023, my lord. And in the 23, my lord, the officer, what is here? My lord, if lordship, that is the whole, my lord, the things. So therefore, my lord, I don't know why the other party is objecting from interference of this LPC, my lord, the impugn order, my lord. Admittedly, my lord, by cancellation, if lordship interfere with this impugn order, my lord, this will not have any decided, my lord, will not decide the rights and titles over the said disputed land, my lord. Of course, it will be decided by the, my lord, the civil
No,
judge.
but if we cancel this order, recall and cancel,
Ji.
then this thing will be in your name.
My lord.
Yes. This LPC will be revived.
No, my lord. That will be the, again, that will be not revived. It's because of subject matter issues with us before. No, exactly, that is the, my lord,
If
the
it's
things.
recalled and cancelled.
My lord,
if then-
cancellation.
Then it is, if we
My lord, my
set
lord, may,
aside this, then it will be in your name.
my lord, may kindly, my lord, the appreciate that aspect, that cancellation, my lord, in lordship may set aside this order, but this setting aside will not bearing any effects to the, my lord, the proceedings of the, my lord, the civil judge. It's because the rights and titles of the land will be admittedly decided by the, my lord, the civil judge.
Instead of setting aside,
That type of document.
see, instead of setting it aside, we can simply say the operation of this will not be affected
My lord.
till the
Yes,
disposal.
Yes,
Will
ma'am.
not be put in effect or
Yes, ma'am.
something, because to whom the land belongs to. what
Yes,
that
my lord.
cannot be
Exactly, my
decided
lord.
At this stage.
That is the, my lord, the whole
Since the
prayer.
matter is pending, when this order, you will have to put it before the senior civil judge.
Exactly, my lord.
Now, this matter also will be placed before the senior civil judge.
My lord, that
Okay,
is not before the senior civil
So
judge.
you have to place this also before the senior
My
civil
lord,
judge.
that was the subsequent proceeding, as I have already pointed out. Therefore, my lord, this will not, my lord, given any, my lord, this may be, my lord, the
Because it is for the
operation
senior
of this.
civil judge to decide regarding this also. It has
Yes,
to be
madam.
taken as a whole.
Otherwise,
Because
my
the
lord,
senior civil judge can decide that the whole land was actually bought by her, and therefore the LPC which was issued to you when you are not the owner should not belong to you.
my lord, what I
Then
am
we can
thinking is,
confirm this.
I am, my lord, the head of the one proceedings, that learned civil judge will definitely say, he, on one occasion, the additional deputy commissioner cancelled the, my lord, the LPC issued in your paper that has not been interfered with.
In evidence, if it's found that you are the one who purchased everything.
Yes, madam.
And the respondent number 5 has nothing to say in the matter.
My lord.
Because then they'll record the evidence.
Yes, ma'am.
Isn't it? Then from the witness, your brother will be examined, whatever. Then it finds that this lady, respondent number 5, has not purchased the land, but you are the one who had purchased it. Then automatically this order also will be set aside
My lord,
in your favor.
yes, my lord. My lord, may kindly appreciate
So it
one.
needs evidence.
My lord, may kindly appreciate one step ahead, my lord, that during the proceedings of the civil judge, there will be an occasion, my lord, in simply, my lord, just simplify the entire thing, my lord. One occasion, my lord, that will be again, my lord, bearing effects on the other party, my lord. What I'm making submission is that one occasion will be there wherein learned civil judge will say, since rights and title has already LPC issued in my paper has already been interfered with by the issuing authority by cancelling and recall. If that is not suspended, if that is not interfered with by this honorable court, well, that will bearing a serious effect on my rights and title before the civil judge, my lord. So therefore, my lord, that is the one, my lord, the aspects which we have to, my lord, rethink of, my lord. That is the one thing, my lord,
What
which,
is this anyway? This is your written submission.
no, my lord. I have not given any written submission.
But I have submitted this.
Huh.
May begin that.
So therefore,
Wait, so anyways, I've got your point. I've got your point. So what is this?
so therefore, my lord,
Hmm.
interference of this, my lord, the two impugn orders is very much, my lord, the
Okay, we'll just pass an order that cancellation at this stage, the court will not find it appropriate because it could interfere. However, since the matter is pending, the operation of this is
My lord.
stayed.
My lord.
Okay, and this may
Yes,
be
madam.
decided.
That will
afresh.
not bearing any effect, my lord, in the proceedings of the learned court below, my lord. Yes, my lord,
We'll
that
just
much
make
only
it
I
that
want, my lord.
because at this stage,
Yes.
otherwise we'll have intensive hearing on this.
Yes.
Notice is required or notice not required.
Otherwise-
Whether notice should be issued or not, all that leave for the senior civil judge to decide, isn't it?
No, my lord,
Ah.
again, that is one aspect, my lord. Just in appeal, my lord, as lordship is, my lord, well aware, my lord, in appeal, my lord, the proceedings, this is first appeal, my lord, against the order of the village authority under the.
So you
In
can
appellate
always, you
jurisdiction-
can always apply for new documents to be considered by the appellate court. You can
Yes,
do
my
that also.
My lord, if,
with all
my
this
lord, in
evidence.
one way, my lord, in simple way, my lord,
Hmm.
if this or impugn order is not, my lord, interfered with by your lordship, my lord, this will be bearing effects in my appeal proceedings, my lord. It's because one occasion, my lord, the additional deputy commissioner, which has been, my lord, the LPCs which has been issued in my favor has been cancelled, my lord. Nothing remains, my lord.
But the lady is saying it belongs to me, so she's also saying it belongs to me, not you.
So therefore, my lord,
Isn't it?
operation of the operation, my lord,
So
operation
your
of
LPC also.
operation of this, my lord,
to be
this operation
considered
of
or
this
not?
may be suspended, my lord. Of course, my lord, this will be decided by the additional deputy commissioner, or my lord, I'm sorry, my lord, civil judge. My lord, operation of this may be, my lord, just suspended and rights and titles will be decided by the my lord additional the civil judge. That much only, my lord. Nothing more remains, my lord.
No, anyways,
My lord, my learned friend has started his argument. The first word he had used is agreed by this impugned order, page 22, because this was cancelled, recalled and cancelled without issuing notice.
Notice,
No, my lord, that is totally misleading facts. Your lordship may kindly come to page 22. Page 22. Paragraph 2, my lord, 2 and 3. May I read, my lord? On receipt of the above complaints, notice was issued to Sri Kabak Bhatt on 29 August, directing him to appear to show cause as to why the aforesaid LPC should not be cancelled, fixing the next date on 4th September 23. Sri K. Bhatt has prayed 4 weeks' time of extension to file his reply. Therefore, the next date of hearing was fixed on 18 September 23 by notice numbers dated such and such. And Sri Tana Punap, ex-JPM and Sri Karaniko were directed to submit their statement on the part of relevancy to the signatories in the LPC form of Kabak Bhatt. Further, on 31 August 2023, Sri Kabak Bhatt appeared and applied for supply of the copy of the complaint, which was accordingly handed over to him. Fourth, Sri Kabak Bhatt filed his written statement on 13/9/2023. The main contention of Sri Kabak Bhatt is that the LPC were obtained after following all necessary formalities according to the procedures established by law. It is not done surreptitiously and fraudulent, and the same was obtained legally in free and fair and transparent manner. Here, two aspects are revealed. First is his stand that no notices were issued to him is totally a false statement.
We are not
Secondly,
saying that no notice
please,
has been issued.
let us not.
My lord, notice has not been issued in favor of respondent number
No.
5.
You started your argument. You started your argument on the same.
Yes.
Now, secondly, was obtained by following the due process of law. Your lordship, if you just kindly come through that file, there is a office memorandum, copy of the office memorandum. On the last occasions, I have placed a copy. Otherwise, I have one extra copy here.
See, the whole issue later will be after adducing evidence whether the LPC issued to the petitioner is correct or not, even in spite of whatever the due processes of law has been followed. If the state land is bought by respondent number 5, then the LPC is again subject to cancellation anyways, isn't it?
Yes.
That's the whole thing.
This office memorandum, may I read, Malad? The government has been considering to evolve a proper and simple procedure for issue of possession certificate of the owners of private land in various places of Arunachal Pradesh. Such certificate is considered most essential by an individual for obtaining financial assistance from various institutions such as nationalized banks, AP State Cooperative Apex Bank, Tea Board, Coffee Board, Rubber Board, Industrial Development Bank of India, etc. In view of the above, the government has decided to adopt the following procedures for issue of possession certificate in favor of the land owners as and when desired. A. The landowners who desire to obtain possession certificate in support of his land, they shall submit an application in the form prescribed in Annexure A, along with following materials or documents to the administrative authority of the area where the land is located. 1. Certificate from the Forest Department mentioning the land in question does not fall under reserve forest area. 2. Certificate from the village council, village headman, vice president, council committee that the land is actually owned by him and it is not a joint property, as well as land is free from all encumbrances. 3. Sketch map of the land in triplet, duly countersigned by the vice president, council committee, village, or then, Malad, on receipt of the above application, the administrative authority of the locality shall arrange to inspect and measure the land in question with survey team, for which he shall issue a notice as per form prescribed in Annexure B with a copy to the following persons of the locality: Gambura, GPM, Ansal Samiti member, applicant, persons holding land in the 4 sites. On completion of above inspection, the administrative authority shall arrange to issue a notice for no objection from the public of the locality as per form prescribed in Annexure C. On completion of above course of action, if it is established without any doubt that the applicant concerned is sole owner of the land, the administrative authority shall recommend the case to the concerned DC as per form prescribed at Annexure D for issue of possession certificate. The DC on receipt of the recommendation from the administrative authority shall examine the case, and if it is found in order, he shall recommend the case to the government for approval, and after obtaining the approval, they shall arrange issue of possession certificate as per Annexure E. A wide circulation such and such and such. The next page, this is the corrigendum. In partial, next page. In partial modification of the office of such and such, all ADCs holding independent charge in the state are empowered to issue land possession certificate up to 5 hectares for any purpose, including cultivation, to the indigenous inhabitants of Arunachal Pradesh in accordance with the existing procedure and instructions. All cases for issue of LPC up to 5 hectares shall be examined and decided by the ADCs at their level without forwarding them to the government in terms of the procedure prescribed under office memorandum such and such and such. Shall be issued by ADC on the strength of no objection certificate to be issued by the Divisional Forest Officer of concerned jurisdiction, and also fulfillment of other conditions. Further, whenever ADC has been already exercising the power under any order issued by the government earlier in relation to their power and function, exercise of such a power shall be deemed to have been consistent with these notifications. Now, this is the background. Now, let us see how they have proceeded. You Lordship may kindly come to page 27. 27. Well, it's totally fraudulent manner they have done it surreptitiously. Now, this is the application as mentioned is Annexure A. Now, here, who had, from where this application has originated, through the ESC circle officer, nothing is there, blank. Then down below, Your Honor, Your Lordship, there is no date when this is being applied. Even the officer who had signed this, he did not put his signature. He put his signature, but no date. The next page, Malak. Next page, Malak. This is form of notice for inspection of lane. On the right side, Malak, number, date. Malak, there should be a file number. The proceeding has to be drawn. Now here, Malak, down below, memo number, everything, in entire all this, no date is done on which day this was issued, except in the middle portion, Malak, whereas the ESC Balijan designated of the administration will visit the above land on 18/7/2018, Malak. Malak, this date may be noted, Malak. 18/7/2018. Now, Malak, here, page 29, this is notice for written objection. Here also, my lord, no date when this was issued, no file number, memo number, nothing. Here also, the date of visit is 18/7/2018. Now, at page 30, no objection certificate. Here in the middle portion, authentication by the concerned GBs. Certified that I was personally present during the field inquiry in respect of the application number. Well, it is blank. By Mr. Such and Such, dated 9/2/2018 at 2:45 PM. Palila Such and Such. Now, this is date is 9/2/2018. Whereas the inspection time has been fixed on 18/7/2018. Now, here in page 31, this is the application form for the other LPC. Here also there is no date from where it originated, nothing, Malad. Here also same, the authority who had signed here, he did not put his date also. And page 32, also the same notice of inspection, 18/7/2018. No date, nothing, no memo number. And notice for written objection is also fixed on 18/7/2018. Now, my lord, here, page 34, this is the recommendation of administrative authority for possession certificate. Well, here also, the person who has signed this, he did not put his signature, he did not put his date when this was issued. Then, my lord, at page 35, also for the second plot, this is also the same. The inspection is shown as 9/12/2018. Now, at page 26, it is 9/02/2018. Here it is 9/12/2018. Whereas inspection is fixed on 18/7/2018. Here also, my lord, there is no date, nothing. And there is no any recommendation from all these authorities which are concerned.
So what is the finding of the additional?
No finding, Malad.
Commissioner? No,
Thereafter,
additional, huh?
thereafter,
The impugned order.
thereafter, yes.
No finding to that aspect. Only non-issuance of notice to the respondent number 5 is the only finding.
In any case, violation of principles of natural justice is always a ground for recalling, review of any decision, Malad. Now, in my just a brief written, I have just completely described.
See, the impugned order, that's what he's praying for setting aside. So we can look at the impugned order, what is wrong with it, isn't it? And the rest, whether it's signed or not, all that, I think we'll have to call the
Yes,
concerned.
paragraph 9, my learned friend has read out. And
Wait, page?
here, paragraph 6 also.
Page?
Paragraph 6.
23 of my report.
23. Yes.
Malad, paragraph 6. Sri Tana Punatara and Sri Kara Niki had given their written statement and had withdrawn back their respective signature given in the application form on the ground that they were misled by Sri Kabak Bhatt, and they stated that the land in question belongs to Srimati Vicky Sapyong, alias Vicky Sapyong. The statement of Sri Kabak Takum, Srimati Kabak Mete, and Srimati Kabak Nacho indicates that Srimati Vicky Sapyong, alias Srimati Kabak Sapyong, and Sri Kabak Bhatt both came in connections with the land in question years ago in 2006, and Mrs. Kabak Nacho stated that both husband and wife came to her in her quarter and requested her to go to Holongi for want of purchasing the land from Sri Kabak Takum and Srimati Kabak Mete. Subsequently, they went together and met Sri Kabak Mete and Kabak Takum. Both Mrs. Sapyong and Mr. K. Bhatt purchased a plot of land, and one of the prime eyewitness, Mrs. Kabak Nacho, stated that in presence of her, Srimati Kabak Mete had received a sum of rupees 2 lakhs in cash from Srimati Vicky Sapyong, alias Kabak Sapyong, on 15 February 2006. Now, my lord, therefore, I had an interest over the land, and this does not belong to the petitioner. Unfortunately, this office is conscious of lack of jurisdiction on claim of ownership or competence to make any findings on the ownership of the land in question or any other claims but put forward by Kabak Bhatt. Also, this proceeding ignores the issuance of notice to land possession as due process was duly followed. Now, 9 is, I'm reading it again. This office has perused the official records of the process issuance of the LPC and also compared with the annexes attached by the complainant Srimati Sasensas. It is revealed during the statement that Srimati Sasensas was not aware of the entire process of issuance of LPC, and that non-issuance of notice to Srimati Vicky Sapyong Eliza Sensas suffers from irregularity and in violation of the principles of natural justice. And it may be noted as such that the LPC application form does not have any provisions in the format for notice to expose for inspection and written objection. But, Your Lordship, this may be specifically exposed, will be given notice, may not be there, but public notice is there.
And they were divorced, isn't it, at that time?
Yes, and it is pertinent to mention that both had purchased the land in the year 2006, but Sri's alone got LPC issued to him without any acknowledgement to Srimati Vicky Sapyong Eliza Kabak Sapyong. Now, my lord, these are the factual aspects which were found by the ADC, and this goes to show that there was some surreptitious element was present. Now, on the basis of this, as Honorable Supreme Court in 1999 4 SCC had
What?
yes,
What does it say?
1999 4 SCC.
(1999) for SCP
4 SCC.
page
Page 396.
1994.
Yes, 1999.
Not four.
Sorry. I think I have mistakenly written 1999 4 SCC. Now, that upon, my lord, these aspects, because this was issuance of LPC the decision was recalled on basically for suppressing material facts, and then in violation of the principles of natural justice. Now, as far as the government side is concerned, they have filed their affidavit. They have taken a stand also, but I won't go through that. But then in paragraph 4, they have categorically stated that the LPC were issued not as per the procedure. Therefore, that has been cancelled. Now, my lord, I have already submitted one thing that supposing if the prayer of the petitioner is allowed, this will have two consequences, serious consequences. One is, rightly or wrongly, the lower court has already given a decision deciding the title ownership. Now, if this LPC is revived now, what will be the consequence? This will amount to directly interfering with the
Yes, returning it back when it
yes.
is.
Then secondly, this will amount to deciding the ownership, although it is disputed. And then in the writ court, it may not be.
Yes,
permission.
so here the finding of the additional DC is with regards to when the land was purchased, who purchased, isn't it? All
Yes.
this, which has yet to be decided.
And
And because of that, it
that has
was
been decided,
recalled
but this is under appeal.
Yes,
So
which is
that
under appeal.
that title
So I think basically it will be more appropriate if we take note of the fact that the matter is actually pending before the senior civil judge regarding the ownership. Okay, and this court has decided at this stage not to interfere. And this impugned order is also to be placed before the learned senior civil judge. It was not placed. You're saying this was not placed, isn't it?
No, it was placed. It is there.
The appeal
It is part of the records.
If it's part of the records, then you leave it. We should not interfere. I
Yes.
thought it was not part.
No, my lord, my only submission is that this honorable court may just observe that since these are it is submitted that they is under appeal, so that appeal let the appeal proceed as per law. And
Exactly.
as far as this concerned, my lord, this court may not interfere in this.
My lord, may kindly observe one thing.
Before that, my lord, in that Supreme
Yes,
Court
yes.
judgment,
Let's see.
paragraph 8, page
Let's
number
see what you
401,
want to point out.
paragraph 8.
Hmm.
In
Yes.
our opinion, my lord, in our opinion, a tribunal or a court may recall an order earlier made by it if one, the proceedings culminating into an order suffers from the inherent lack of jurisdiction and lack of jurisdiction is patent. Two, there exists fraud or collusion in obtaining the judgment. Three, there has been a mistake of the court prejudicing a party. Or four, a judgment was rendered in ignorance of the fact that a necessary party had not been served at all or had died and the estate was not represented. E, the power to recall a judgment will not be exercised when the ground for reopening the proceeding or vacating the judgment was available to be pleaded in the original action but was not done, or where a proper remedy in some other proceedings such as appeal or revision was available but was not availed. The right to seek vacation of a judgment may be lost by waiver, estoppel, or acquaintance. A distinction has to be drawn between lack of jurisdiction and a mere error of exercise of jurisdiction. This part is not
Not relevant. So we leave it.
only
Anyways,
violation of principle of natural justice and not issuing notice and not following the due procedure itself is a ground for recalling.
Anyways, whether we will uphold the order of the Deputy Commissioner, additional, or we will set it aside, I think it is not appropriate for this court to look into the matter, considering the fact that the whole matter has been placed before the learned senior civil judge, isn't it?
Yes, ma'am.
So otherwise we'll have to again decide.
Madam, my submission is, as I've already pointed out, madam.
If we stay the operation, then you're being the
Yes.
owner.
I'll be
but
not owner, madam. That observation may be made, madam.
No,
Operation, I'll be not the owner, madam.
Then that will not have any sense. If we stay, then you're
No,
going to have. the
now,
owner.
madam, may kindly appreciate,
No, I'm not inclined to interfere at this stage.
madam, may kindly
Huh.
appreciate one thing.
Huh.
Lordship, may I take your lordships to the again page number 46, madam?
What?
Money receipt, madam.
Huh.
Madam, this has been paid and transaction has been made between the madam, so-called purchaser and this between the so-called seller.
The evidence will have to be taken. They will call this person. They'll
Madam,
call the
My
witnesses.
lord, may
and
kindly,
see.
my lord, may kindly appreciate one thing.
Because
If
here,
this money has been paid to the
Huh.
one persons who has, my lord, the claims to be the seller of the land, my lord, additional deputy commissioner ought to have that findings there. If my lord, the transaction is made between them, my lord, recovery has to be done.
evidence has to be taken.
My lord,
Deputy Commissioner
My
also. they will be
my lord,
called.
I'll leave it to, of course, my lord, I'll leave it to your lordship. But my lord, may kindly appreciate one thing. My lord, under appeal, is it possible to raise all these things? The
You can.
No,
You-
my lord, this
So you do
appeal
your
is,
homework.
appeal is, my lord, limited.
But fresh evidence also can be taken. You can pray, where's the section 46 or something of the.
So therefore,
CPC.
It can be de novo.
My lord, therefore, my lord, de novo is not done, my lord, as because the appeal provision is very limited, as because that is under procurement. So, my lord, may kindly appreciate one thing, my lord, if lordship, even if it is not interfere, even if it is interfere, my lord, that may not bearing effects on the proceedings of the, my lord, that observation, my lord, one observation may be made, my lord. That
Okay,
is, my lord.
yes. Fine. Where's the,
My lord,
we'll leave it at that. I'll not
Yes.
pass a long order, I'll make it a short one. Okay, when we'll dispose.
Well,
of the
otherwise, again, this
evidence.
will have bearing effects on the, if
Ah.
lordship will not interfere, definitely learned civil
Yes,
judge will
yes,
say,
yes.
no, this has not been interfered by the honorable, the High Court. So, therefore, my lord, my lord, fairly submitting is that aspect only, my lord.
Okay, fine.
my lord, the petitioner had filed an IA annexing the order of the village authority. And this honorable court, seeking stay of the, this
Yes.
honorable court had flatly refused and that.
To stay what?
Stay of the,
Okay, the
decision of
Kabak
the,
decision.
yes,
No, because it's been appealed against, so
my
we
lord,
cannot.
that become emphasis, more of a.
Yes, anyway.
And irony is, my lord, one thing, my lord,
Mhm.
the the village authority who does not have, my lord, even, my lord, able to put their signature, my lord, beautifully, my lord, it has been, decision has been passed in English language, my lord.
So you
Then
will
all-
bring that before the learned
Well,
senior judge, okay?
Management, everything has been
And
done by the respondent
additional
number of.
evidence and any evidence which was not available.
My lord, my lord.
at
Just I am
before the
pointing out, my
above,
lord.
You can, this in pray that it can be considered.
Yes, ma'am.
Isn't it?
Just I am pointing.
The Kabang decision is with
No,
the
no, no,
annexer
no,
5.
oh, yes, we'll not look
I-
now. Okay, that's not required. Anyway, I heard Mr. M. Kato, learned counsel for the petitioner, along with Mr. You're for the respondent number 5.
Five,
Isn't
sir,
it?
Tony.
H.K. Jamong, is it?
T-Pert.
Okay,
Tony.
T. Learned counsel for respondent number 5. Also heard, are we going to,
I'm for 3 and 4.
okay. You're for the Kamdok, is it? Learned Standing Counsel for Land Management Department and Mr. S. Tapin, is it? Yes, because I'm very bad at remembering names. Okay. Learned Senior Government Advocate for the State Respondents, number 3 and 4. The Learned Counsel for the petitioner submits that the instant writ petition is filed for setting aside the impugned order dated 18th September 2023, passed by the additional deputy commissioner, wherein the LPC issued to him LPCs. Have you mentioned the numbers?
Yes.
But the deputy commissioner has not mentioned.
Mother, I mentioned,
Wait. Okay, the LPC number 03/2024, no, 2014, measuring 49066 square meters. You said there were 2, isn't it?
yes.
You see, I think the deputy commissioners, so it has the same LPC number.
My lord, 2 LPCs,
Same number. So we'll make it LPC certificate number ADC/BNJ/LPC-03/2014, measuring 49066 square meters, and the land and the LPC certificate number. Now here's the same number.
well,
Area is different.
Huh?
Lordship may refer the area.
area is different.
Date is
Number-
same, number is
Okay,
same,
the
but
number
area is
can be the
different.
same.
Area
Okay,
is different.
it's the same number for the plot of land at Hologi, measuring 47961 square meters.
Correct.
And another plot is 49066.
Only this thing is different, the area, okay? Considering the LSB so and so and so. Okay. The learned counsel submits that the impugned order recalling and cancellation of these LPCs is liable to be set aside since the petitioner had followed the due procedure of law at the time when the LPCs were issued in his favor. The learned counsel further submits that the said landed property was purchased by him. However, the respondent number 5, to whom he was married during the period 2002 to 2010, has now claimed ownership over the said land, which resulted in the said impugned order. The learned counsel for the petitioner has also brought to the notice of this court that the respondent number 5 had approached the Gaon Bura, is it?
Village authority.
Village authority. What do you call it? Gaon Bura?
My lord,
The
as per
village
the
authority.
village
We'll make it the village authority.
Village customary court, my lord.
Village, okay, customary court regarding the ownership of the state land, which was decided in favor of the respondent number 5, against which he has filed an appeal before the senior civil judge. Which place?
UPI.
UPI.
My lord.
Good stuff.
And same is pending.
And the same is pending till date. The learned counsel for the petitioner thus prayed that during the pendency of the said case, the operation of the impugned order may be stayed. Okay, okay, then Mr. So-and-so, learned counsel for respondent number 5. On the other hand, submits that the matter, since the matter is pending before the senior civil judge, it may not be appropriate to stay the operation of the impugned order dated 28 September 2023. And further submits that the reason why the said order was issued was because no notice was issued to respondent number 5 at the time when the said LPCs were issued in the name of the petitioner. Having heard the submissions made by the learned counsels for both the parties, this court, considering the fact that the issue of ownership / title of the said landed property covered by the LPC's number, same, okay, copy paste, is pending in the court of the senior civil judge on appeal against the decision of the village court, okay, concerning the ownership of the said land. This court found that it would be inappropriate at this stage to interfere with the order dated, impugned order dated so-and-so, which has set aside or recalled the LPC, said LPCs, recalled and cancelled the said LPCs.
28/09/2023.
In view of the above, this court finds that it would not be appropriate to pass any order either setting aside the impugned order dated 28 September 2023 or make any observation regarding the ownership of the said LPCs, okay, number. Since the matter is pending before the learned senior civil judge, UPI. Accordingly,
Is stated to be pending in the,
said to be pending before the senior civil judge.
this court is not aware.
Yes. Accordingly, WPC number 504/2023 stands disposed of with the above observation, and the observations made by this court will not have any bearing on the decision of on the findings / decision of the learned senior civil judge, UP.
Well,
I think we can leave it at that. So I'm not citing a decision, sir, no.
well, otherwise also that is not relevant because that is the
Anyway,
tribunal
so-
and the law. Deeply obliged.